lordship. Otherwise, but regarding that, matlab, he should obviously I should supply at that. Matlab, the original copy has to be given to the court at the time of production. That is.
Okay, had Mr. Swinson Council appearing for the applicant. Stop. Check it is Parasar that it is this is an application under section 483 of the BNSS 2023 for granting bail to the petitioner who was taken into custody on 4/11/2025 in connection with Polasbury PS case number 269 of 2025 under section so and so page 1, the second was title, huh? Learned Council has submitted that 4 persons had been apprehended on the basis of an FIR dated 2/11/2025, which were to the effect that 11 numbers of cattle had been recovered from a jungle area at Rani Jaipur, which cattle, as per the FIR, had been left there by the 4 arrested persons after stealing them. Full stop. As per the FIR, the 4 arrested were suspected of being involved in interstate illegal trade and transportation of cattle, thereby causing cruelty to animals. Full stop. The present applicant had been arrested on the basis of a statement made by the aforesaid 4 accused, aforesaid co-accused, and the forwarding of the applicant to the learned CJM Kamrup Amingao reflects that 111 number of cattle had been recovered from the huge godown / concealed boundary of the applicant. Full stop. It is further stated in the forwarding report that the accused was asked to produce valid documents for ownership of the seized cattle but failed to produce any valid documents, and this gave rise to a reasonable suspicion and his involvement in the interstate trade, possible theft and cruelty to animals. Full stop. The Learned Council for the applicant has submitted that a bail petition had been referred before the Learned JMFC Kamrup Amingao, which was rejected on 20/11/2025. Full stop. Learned Council for the applicant has drawn the attention of this court to the notice served under section 47 of the BNSS, to emphasize that the notice on record did not reflect that the grounds of arrest had been made, the
notice was served to
the notice was served on
arrested accused.
Was not served on the arrested accused,
Okay.
and rather was served on some other person. Full stop. It is the submission of the Learned Council that the aforesaid omission was sought to be explained by the investigating officer, stating that the notice had inadvertently remained in the case diary and only a rough copy was placed on the case record. Full stop. Next paragraph, the Learned Council has submitted on both the grounds. On the ground that the applicant had not been served the notice under section 47 BNSS, and also in view of the fact that the only allegation against the applicant is that he failed to produce necessary documents before the seizing authority, comma, the applicant deserves to be released on bail. Stop. We have gone through the petition and the records annexed thereto. Several receipts of several receipts have been annexed to the same
All the, or
to show that the petition, the applicant had bought the cows by legal means.
Always given or not, I have not verified.
Uh-huh.
From his submission.
Several, I'm
yeah.
saying that we have gone through the records which
Ma'am,
where there are receipts to show that he had bought legally. In view of the Mr. K.K. Parashar, current APP has objected to the bail petition, saying that release of the applicant at this stage may hamper the investigation. Full stop. However, he has candidly submitted that from the records, it does not appear that the notice under section 47 had been served upon the
accused.
upon the accused, and
On the
Same-
date of arrest.
on the date of arrest, and the same fact is also reflected in the order dated 2011-2025, where the investigating authority has admitted that the notice given to him was not a correct notice. Good stuff. In view of the above, comma, this court is inclined to grant bail to the petitioner. How much?
30,000, 40,000.
On submission of a bond of rupees 50,000, subject to the satisfaction of so and so with two sureties of the like amount, and subject to the following conditions. Huh? Conditions the usual ones you put.
that notice was not served on the date of arrest, that may be.
That we have said. Have we not said the notice was not served on the date of
In the
arrest?
first submission.
arrest, I
that
think I
is
said.
there. That may be, okay.
Huh?
In my submission where your lordship recorded, in that part only that sentence may be added. At the time.
We'll see. I think we have said if it is not
Lord.
said, we'll add it up.
How like lordship?
Adam? Or special.
My lord,
Eh,
in this
forest
case, yesterday it was listed. I have
Yesterday's
this copy
matter,
also, my lord.
some forest matter, it was not served.
Yes, what happened to?
I have served, even it was at the time of filing, it was served, my lord. And yesterday also I have served him the copy, my. Now my,
After some time,
my.
can you find out Mr. Ivo Thakur? Ask.
Lordship.
Item 50 will be taken up along with item 38, which case diary is there
Yes.
with 38.
6.
May please, Lordship. Lordship will get the FIR at page 18, Lordship. What happened, Lordship? Actually, Lordship, the husband of the victim stays at Guwahati to earn a livelihood. And in the meantime, Lordship, the informant has developed some extramarital affairs with one Nazrul Islam of the same village. And on 5/9/2025, said Nazrul Islam stayed with the victim, and when he was coming out at 3:30, some villagers looked at him and confronted. Thereafter, he has stated all the things, and subsequently, the incident happened on 5/9. FIR lodged on 10/9. Lordship. It is a clear case of extramarital affairs, Lordship, and this honorable court has already granted bail to the 6 accused persons. after perusing the case diary and all this time, we have annexed page 22. Oh. Relevant portion, page 24 at paragraph
Yes, what
6.
do you say?
Well, otherwise, well, this say from the same PS, it is allowed by the Justice Kolita.
Hmm.
So this matter may be taken by that bench. Well.
The same PS case is involved.
Same PS,
It has to
well,
go before the same judge.
And
There's some
judge is
notification.
sitting, he's
Huh?
judge is
Ah, he's
sitting.
sitting. But is he taking up this bench? Is he taking up
If
criminal
it is
bench?
rejected by
Rejected.
particular honorable judge, then
Acha.
that matter second time
Then
goes
it's
to
granted.
No,
Any case where the same PS cases number is
yes,
involved,
judge is
unless he
sitting,
is absent.
no. In case of reject.
Huh?
Yeah,
Only case of rejection. So, the
Uh,
first matter we had allowed. Yes.
Lordship, I am ready to cooperate with the legislature. And this honorable court has already
Same.
allowed.
Hmm?
Same.
Yes. Record the presence. Then you write application under 482 BNSS or pre-arrest bail. In connection with from page 1, you please take, huh?
Copyright PS case.
Rest will take this from this order itself at page 23. And you write, Learner Counsel for the applicant has submitted that under similar circumstances with regard to the same FIR, other persons have been allowed to go on bail. Full stop. And an APP does not dispute the aforesaid position. Stop. In view of the above, bail granted. 20,000 surety of like nature to the satisfaction of the IO, subject to the following conditions from here. It's take it down from here.
Published.
Granted, disposed. Yes.
Lordship, CD may be called.
Hmm?
It is a POXO matter. CD may be called.
Notice and CD.
Page 1, you take 482, PS. Huh? PS, since the matter is under the POXO Act, since the allegations are under the POXO Act, notice to the respondent number 2 in accordance with the prevailing notification.
12th of December.
12th of December.
May please, your lordship. Lordship, pre-arrest bail application, lordship.
Huh?
Pre-arrest bail application, lordship. Lordship, the lordship will find the FIR page number 14. Page number 14, lordship. There are two sets of allegation, lordship. First is that lordship, during Naka checking, 3 trucks were lordship intercepted, which were suspected to carry lordship illegal coal without document, lordship. And second set is that lordship, that few individuals, including the present petitioner, were engaged in lordship extorting money in the name of Margherita police for passing such vehicle, lordship. Lordship, in this case, lordship, whatever lordship will find in the middle portion, second paragraph, lordship, on the basis of credible information, lordship has got it. Second
Where?
paragraph,
7th line. in
seventh
paragraph.
line,
Page 14.
page 14, second paragraph, seven line. On the basis of credible information.
8th line.
On the basis of credible information, it was found that certain individuals have extorted money using the name of Margherita police for illegal passing of above mentioned trucks. The names of persons who have suspected to have extorted money in the name of Margherita police are as follows. Bittu Gupta of Biru, he is the present petitioner. Raja Rai of Segunbari, Dhanti Bura Guhai, son of so and so, and others. And Lordship, this Dhanti Bura Guhai has approached this honorable court, and this honorable court was pleased to grant 3 years bail on the day of motion itself, Lordship. Lordship will find at page number 16, the order, Lordship. Considering the fact that he and this person also involved are involved only in loading of coal in the truck. They are employed by transporter, Lordship. They are neither the owner nor the driver of the vehicle. Lordship may kindly see para 5 of the order, Lordship, page 17.
Yes, Koitus.
Malad, it is there, but that was also issued, Malad, without perusing the CD. But one thing is that, Malad, his name is in the first, Malad, suspected to extortion of money
Yes, his
in the
name
name of Margarita Police Station.
Yes,
But
his name is also there.
yes, but only
is also there.
observation is that they therefore submit only his submission. They are involvement only to loading the
Yes,
coal.
Lordship.
But
Square-
extortion of money in the name of Margarita Police, that is that
That is
has
also
to be
there
accepted,
against him,
Malad.
Lordship.
Otherwise,
My contest
Allegations are.
allegation is
Same.
Malad, they are doing the
Same.
duty of loading the coal. That is the submission of the council.
Yes.
But they are also doing the extortion of money in the name of Margarita Police.
That is the only allegation in the FIR, Lordship. Similarly situated, Lordship.
Bittu Gupta's name
Because-
is
Just a minute, Mr. Prasad. Let me tell you one thing very clearly.
Lordship.
We have been doing this for the last 2-3 days.
Lordship.
In case two councils start arguing at
Lordship,
the
Lordship.
same
I'm
time,
sorry.
I will refuse audience to one of them.
Lordship.
On a repeat offense, I will refuse to hear the case at all.
Lordship.
There is some decorum to be maintained.
I apologize.
Have we not heard you?
Lordship.
Have we not heard you? Totally. Yes. What
Um,
were you saying?
Malad, on that other case was allowed without perusing the CD.
Hmm.
But on that day, Malad, maybe Malad, it is allowed, but regarding the loading of the coal, that is the allegation was mentioned. But here, that portion also, they are extortion of money in the name of Margarita Police. That they may submit that we are only involved in loading the coal. But other person, Malad, they are doing extortion of money in the name of Margarita Police.
Hmm.
And that is a serious thing, Malad. To verify that, Malad, CD is required, Malad.
The allegations are very, Lordship, similar to that of Koikil, Lordship.
He
My only role is to, Lordship, to load
Yes.
the coal, Lordship.
Where have you stated that?
I have stated, Lordship, in Lordship, para 3, my petition. He is neither the owner nor the, Lordship, driver.
Owner will not come.
Definitely owner will come, Lordship.
Whether they are
Hey,
involved or not, do you need
page
a-
17, last line, page 17, last line, the order of the court, last 2 lines. He submits that his involvement in the alleged offense is only to the extent of loading the coal in the truck. He further submits that he is not involved in the kind of extraction of money.
Hmm.
So only his submission it was given. My objection is that regarding the extortion of money,
No,
allegation in the
in case he's
FIR is
extorting
there.
money, the case will take a different turn. Tell us in the face of this order, would keeping him in custody and any custodial interrogation is required or not? We're only on that. We are not going into the allegations.
One thing is to be very clear, my lord. After getting the interim bail, he will appear, he will give the statement. But regarding extortion of money, nothing, not a single word will come out. That is after the jacket of that order.
Although the court is not supposed to go into to that extent, but
Nothing will come out regarding the extortion.
keeping him now.
Similar
Hmm?
order is passed, my lord. But that is the fact, my lord.
So if he is kept in custody, he will say that I did it.
May.
Doesn't matter then. Even then, it doesn't matter. It is before the police official. Allowed. Allowed. This will remain the same as in this one. It is an anticipatory. This is an application praying for grant of pre-arrest bail to the a petitioner under section 482 of the BNSS in connection with Margherita PS case number 127 of 2025. Stop. The so-and-so learned counsel for the applicant has submitted that the applicant do name in the FIR, is not involved in the offense alleged in the FIR, full stop. He has further submitted that another named co-accused has been allowed to, has been granted the privilege of a pre-arrest bail by order dated 19/11/2025 in AB number 2734 of 2025. Full stop. We have perused the materials on record. उसके ऊपर लिखेगा Mr. KK Parashar Learned APP has objected to the prayers made by the applicant on the ground that allowing the petitioner the privilege of pre-arrest bail at this stage may hamper the investigation. के बाद लिखेगा we have perused the materials on record in the order passed by this court in so-and-so. Court is of the opinion that the privilege of pre-arrest bail can be granted to the petitioner subject to the following conditions. Disposed of.
Obliged, Lord. I'm sorry, Lordship, sometimes we get carried away, Lordship. Obliged.
May please, your lordship.
Yes.
This matter pertains to rejection of my prayer seeking Zimma of a vehicle.
Ah,
Well, in this case, I am the registered owner of a truck, and to be very fair, my lord, this truck was intercepted by the police, and 9.9 kgs of opium was found in that truck. I am the registered owner, and the vehicle was seized, and I was also arrested. Subsequently, I was granted bail. Now, normally, my lord, in such matters, my lord, there are 4 scenarios basically where Zimma is to be considered. Normally, Zimma is not to be given if the drugs is recovered from the possession of the owner. Secondly, my lord, if it is recovered from an agent of the owner. Otherwise, my lord, if it is recovered, if the vehicle is stolen, somebody else has used the vehicle, then it can be granted. And if it is recovered from a third-party agent, third-party occupant of the vehicle, my lord. So it is our case, my lord, that there is a driver of the vehicle, and the driver of the vehicle was transporting the contraband without our consent, my lord, without our knowledge. So, my lord, for that, your lordship will have to examine the case diary and the trial court record. So, at this stage, my lord, I only pray that the scanned copy of the trial court records and the case diary will be-
Yes, my lord, but it is very clear from the my lord, record rejecting the observation of the court, page 50, para 9. My lord, kindly only.
that is what I was thinking.
Right.
The truck is his, the driver is
Yes,
his.
but
Can you
that-
say third party?
That is the observation, my lord.
Can you say third party?
No, my lord,
Page
that is our
50,
projection, that is our instruction, my lord. I'm trying to,
page
your lordship
50,
will independently examine that. That is
I
my only
understand.
prayer.
page 50, para 9.
Ah,
Considering the seized truck is prima facie used in the transportation of the contraband and the registered owner of the said truck, namely Tarshan Singh, is himself in the prime accused of this case.
one
That's
step ahead. It is his driver.
He's
It's not as if the driver was somebody else, his driver had got down.
Right. Sometimes we are also
Well,
constrained, my
no,
lord,
no
with-
wrong in the order.
Mr. Swens, counsel is paying for the petitioner. The grievance in this petition is against the rejection of the Zimma prayer by the petitioner who Zimma prayer for made by the petitioner for Zimma for custody of the truck involved in an offense of carrying
opium, my lord.
opium. Full stop. The
9 kg.
petitioner is
9 kg.
one of the accused.
ಇದು ಹೊರಗಿಲ್ಲ.
Stop in the, accused in the case, full stop. Call for the case diary and a scan copy of the
Trial court record.
trial court records. Stop when?
Ah, 11, 12, any?
11th, 12th.
12.
But case diary also
Yes, sir.
scan copy, my lord, because
Ah,
It says, case diary and scan copy of TCR, na?
no, I'm saying, scan copy of the case diary, because original case diary since trial has also comments, my lord. So they may have
Trial
Trial
comments.
contract along with the scan copy of CD.
CD, man.
Trial court scan copy of trial court record along with the scan copy of CD.
Deeply obliged.
The trial is on.
May I please, your lordship?
Yes.
Your lordship, kindly the matter be fixed to your lordship.
Two. Is the grievance.
Setting aside of the judgment,
Huh?
setting aside of the judgment of the.
At this stage, notice has to be go. We are a limited formal party here, because 125 proceeding, but notice has to go,
Maybe he'll pray for an interim.
Otherwise, he is the husband, yes, interim.
Some allowance has been granted. Maintenance, he may try to press for a.
Or add to.
Add to.
Oblige, your lordship.
What did you? I said, do what did you? Yes, sir, no copy.
I am praying that CD may be called for my
No,
lord.
my lord, kindly have a look, my lord, page 11 of that is the my offense report, my lord.
Wildlife protection,
No,
you are caught with pangolin skins.
my lord. Now, my lord, kindly have a look, the page 18 of the petition, my lord,
Ah,
section 47 notice, my lord. Section 47 notice, my lord.
mm,
So, grounds of arrest, sufficient evidence is found against you and you will be forwarded before the honorable court and you may apply bail before the honorable court.
mm.
The notice has been explained to the accused person in Hindi language and he understood and acknowledged the same.
Hmm.
The put his signature Bengali, my lord. Apart from this, my lord, in all notice, my lord, it has been explained in
Hmm.
Hindi. In all the other notice also, 47, I have annexed, my lord, it is explained in Hindi, my lord, written in English. Now, recent judgment, lordship is very much aware,
No, no, I did not understand. Explained in Hindi?
Hindi, my lord, written in English, my lord.
Ah,
Now, my lord, recent judgment of effects of November 2025, my lord. Where, my lord, para 56, my lord.
ah,
Para 56, my lord.
what does it say?
It, in conclusion, it is held that the constitutional mandates of informing the arrestee, the ground of arrest is mandatory in all offences under all statutes, including offences under IPC. All statutes, including the ground of arrest must be communicated in writing to the arrestee in the language he or she understands. In case where arresting authority party unable to communicate the ground in writing on or soon after arrest, it will be done orally. The said ground of communication in writing within a reasonable time, and in any case, at least 2 hours prior to the production of such. In case of non-compliance of above, the arrest and subsequent remand would be rendered illegal and person will be at liberty will be at liberty to be set free, my lord. This is the recent judgment of apex court, my lord.
What do you want to say on that?
Now, my lord, in
You
this
want to
case,
say
my
about
lord,
that?
what happened? In fact, my lord, notice was not furnished to me, my lord. These are paperworks, my lord. Like, kindly have a look, my lord. There is no date mentioned in the notice itself, my lord. The signature put by the range forest officer, he has no signature at the bottom, my lord. There is no date.
Range forest officer, half
My-
long range, half
my-
long, yes.
He has no date, my lord. And signature, then, my lord, the grounds of the notice, my lord, as per the verdict of this honorable apex court, my lord, it should be communicated in the language in written, which he or she understand, my lord. Admittedly, my lord, it was communicated in English, my lord. It was explained in Hindi, my lord. By virtue of this judgment, my lord, the petitioner is entitled to bail, my lord. May I produce this judgment before your lordship, my lord? This is of 2000.
So someone signs in Assamese, we have to assume that he does not understand Hindi and English.
No, my lord. that verdict, my lord, it is lordship. And apart from this, my lord, kindly have a look,
Suppose a man from Tamil Nadu is caught
my lord,
here in Assam. Notice is given in Assamese,
my lord.
explained in Assamese.
Now,
He may not understand. We may have person here in Assam given a notice in English,
now by virtue of,
explained in Hindi.
my lord, now by virtue of,
Should we assume that he did not
now, my lord,
understand anything?
this petitioner sails from Barakvili, my lord, neither English nor Hindi, my lord.
So Hindi they don't understand in Barak Valley.
My
That
lord,
is, persons who smuggle these wild animals, they don't understand Hindi.
and apart from this, my lord,
Are we to understand that?
now, my lord, kindly have a look, lordship, the FIR itself, my lord.
Hmm?
In the body of the FIR, my lord, page 11, my lord. Date and hour of detention, my lord. 7/11/2025, my lord.
At 2 p.m.
Lordship,
At 2 p.m. Detection is 5:30.
5:30, my lord.
2 p.m. they had taken, they had
No, in
recovered.
that at around 2 p.m., I along with the staff range detected 3 kg.
Ah,
And in the body of the FIR, my lord, of the, my lord, FIR, it is stated that detected at 5:30 p.m., my lord. And in the fact, my lord, it was stated at 2 p.m., my lord.
so from 2 to 5:30, why he was not arrested? That is what you want to say.
No, my lord. The thing is that, my lord, in all the records, lordship,
Ah,
kindly have a look, my lord, there, the divisional forest officer, my lord, he is also not, the date is not mentioned there, my lord.
hmm?
Date, my lord, when in the lordship 47 notice, my lord.
Let the CD come, we'll decide. 7/11. At the top, there is a date 7/11/2025. Did not? He was produced on, when was he produced before the magistrate?
My lord, he was produced on 8th, my lord, not 7th.
Huh?
8th,
On 8th,
8th.
within the 24 hours.
That's true, my lord, but this lordship, this forwarding report, they could have
Medical
mentioned
officer
only,
7/11.
my lord.
Medical officer says received on 7/11.
No, medical officer, my lord,
Page 22.
page 22, lordship.
All your grounds considered. Now shall we call for the CD?
Oh, my. Only thing is that, my lord, petitioner number 1 is 72 years age, my lord.
Ah.
He undergone major operation, my lord.
Hmm.
And I have annexed his medical reports here, my lord. Considering that fact, my
When
lord,
can you have it, Mr. Bhattakur?
By Wednesday, my lord. May fix it.
That will be third.
Third.
Okay. Third, Mr. So-and-so. Huh? Application under so-and-so.
Bengal.
Huh? Call for the CD. Scan copy of the CD corridor. So it has been submitted that it has been submitted that the petitioner number 1 is 72 years old and has undergone recent medical treatment.
Hmm.
Full stop. Authorities would take note of the same and provide medical assistance if so required.
my-
3rd of December, this one. 11.
A non-bailable warrant has been issued in respect of a complaint case raised under Negotiable Instrument Act. We are the accused in the NIAC case. Once we appeared, but subsequently due to some miscommunication, perhaps with the advocate, we could not appear. And at page 15, 9/10/2025, a non-bailable warrant has been issued against us. So I may be given a chance, my lord. We want to contest. We want to appear.
This was your first non-appearance.
No, my lord. Earlier was there.
Then?
Other orders are there. In the meantime, my lord, we appeared once. Hereafter, again, my lord, we could not appear.
Hmm.
Exact reason, my lord, not known to my lord, me, my lord, what is the reason? But anyway, my lord, we want to appear before the court. We want to contest. It is a case raised under Negotiable Instrument Act for an amount of rupees 30 lakhs. Both the accused and complainant are the construction company. The accused in the complaint case took a loan of rupees 30 lakhs.
You have given only that one order.
Yes, my lord. I have the other certified copies of the orders passed earlier. I have seen in one of the dates we appeared. to our council, but the council did not file the Wakalatnama. So sought for some time and adjournment was taken. So
again
thereafter
absent.
subsequently. Just one chance, my lord, I want to appear and contest. The next date is fixed on 23/12/2025.
23/12.
Yes. If possible, before 23/12, scan copy may be called for if my lord, and chance to the respondent may also be given.
Heard Mr. S. Viswas, learned counsel appearing for the petitioner. The present petition has been filed. Huh? The section 438 of the BNSS being aggrieved by the order dated 9/10/2025 passed by the additional Chief Judicial Magistrate Dibrugarh in NI case number 176 of 2019, whereby non-bailable warrants has been issued against the
Petitioners, my lord.
petitioners. The learned counsel has submitted that the applicants are interested in pursuing and contesting the said NI case, but due to unavoidable circumstances, they were not able to be present before the court on the dates on which the matter was fixed. Full stop. Issue notice returnable. Issue notice to the respondent number, to the sole respondent. Stop. List again on, you said what date?
23/12/2025.
List again on 16th of December 2025, by which time the learned counsel for the petitioner shall also bring on record the earlier orders passed in the
My lord, in
NI
the
case number so and so.
March of the.
Kindly pass over the microphone.
Kuntur. Okay.
My senior is on legs. Kindly pass over the microphone.
Pass over for the time being lage. Objection can this. Oh, it has not come till now. Hello, Pishat Mati, Doctor.
Please, Your Lordship. Lordship, in this case, I was initially arrested in connection with possession of 6.46 gram of heroin, my lord, intermediate quantity. I was granted bail. Thereafter, police submitted charge sheet against me. On 3 occasions, my lord, I was absent with steps. My counsel was there on my behalf. Thereafter, on the next 3 occasions, my lord, I was absent without steps. So first NBWA was issued against me. Subsequently, when the NBWA report was received that I was not available in the address. So proclamation and attachment was issued, my lord. But I had gone to Chennai, my lord, for my livelihood, my lord. So because of that, my lord, this I was not there, and this
With or without intimation to the.
well, I was not there because there was no intimation on my part, my lord. That is the default on my part, my lord. Now PNA is there, case is fixed on 6, my lord, and I intend to appear, my lord, because I'm already otherwise on bail. I intend to appear and contest the case, but because of the pendency, because PNA is there, the moment I appear, there is an apprehension that I may be taken into custody, or even in the intervening period. So at this stage, my limited prayer is, my lord, if the PNA and the NBWA can be kept at abeyance till my appearance on 6, my lord, then trial court may decide, my lord, whether to take me into custody or grant me bail, my lord.
With that observation, my lord,
The present
intermediate, no?
petition has been filed under section 528 of the BNSS 2023. Being aggrieved by the order passed by the Learned Special Judge Sonitpur Tejpur in special NDPS case number 7 of 2025, whereby non-bailable warrants of arrest and proclamation and attachment orders had been passed. Petitioner. Mr. Swenson and a counsel fearing for the petitioner has submitted that the petitioner had to leave, had gone to Chennai in connection with earning of his livelihood, and therefore on 3 occasions, although he was absent with steps,
Initially with steps.
initially with steps through his learned counsel, on the last 3 occasions, the counsel for the petitioner had not represented him in the court. Full stop. The learned counsel for the petitioner has submitted that the petitioner is willing to appear
Page 38, last.
before the special court on the next date fixed, that is 6/12/2025. And it is apprehended that before his appearance, he may be taken into custody. Mr. K.K. Parashar, counsel for the learned APP, has submitted that in case the petitioner is allowed to appear before the special court on the next date fixed, and the requirement of his detention, further detention is allowed to be decided by the learned trial court in the facts and circumstances. Full stop. The same would suffice the cause of justice. Full stop. Having regard to the submissions made, this court directs that,
he will regularly appear subsequently.
that he will only stay the NBW and the P&A till his appearance on the
Appearance.
6th.
And that will be decided
All
by-
further proceedings will be decided by
Matter of
calling, and
yes, yes,
everything
yes.
will be decided by the trial court. Madam
Yes,
Chief
yes.
Referee. The, what did you say? Regard to the aforesaid this court keeps, deems it fit to keep the order dated 16/10/2025.
It will start from 11/8/25.
You read it serially, 11/8/2025, 16/9/2025, and 16/10/2025 in advance till 6/12/2025, to facilitate the petitioner to appear before the learned trial court. Full stop. It is made clear that the aforesaid orders have not been interfered with on merits and on the appearance of the petitioner before the learned trial court, the learned trial court would be at liberty to decide the manner in which the presence of the petitioner during the trial can be further decided. First up, criminal petition accordingly disposed of.
I'm deeply appalled.
Yes.
Lordship, this is a petition for Jimma of his seized cash, Lordship, of 2,90,100, Lordship. FIR is in page 10, Lordship.
Why was it seized?
Lordship, the petitioner had carried the amount for a gold transaction, Lordship. And after being cheated by a group of individual, Lordship, he himself lodged a written complaint, Lordship. And the same amount was recovered from
An
the.
empty cartridge and 1 live bullet. What happens to that? Why was he carrying that? 3 mobile handsets. Yes.
But even then, consider regarding the Jimma, peruse the last order, page 14. Order of the court rejecting the Jimma, page 14. Last page. On perusal, that paragraph, On perusal of the case record, it appears that the petitioner has previously filed Zimma petition regarding the same subject matter, which was rejected by the order considering that the amount was recovered from the possession of the accused person, namely Jamaluddin Sheikh. And ownership of the same can be ascertained only after completion of the trial. So, matlab seized from Jamaluddin Sheikh, now Zimma seeking from by Golu Kumar. So, who is the owner? It has to be ascertained from the investigation, matlab. It is not been ascertained, so investigation has to be completed, matlab.
Is any explanation why Golu Kumar is asking for it?
Earlier also rejected, twice rejected.
Why is Golu Kumar?
Matlab, why he is,
We are asking her, why is Golu Kumar asking for the Zimma? When it has been recovered from Jamal.
Jamaluddin Sheikh.
He has been cheated, Lordship.
Because there.
Oh, yes, report from the IO.
Had Ms. Vensola counsel paying for the petitioner. Stop this. Petition has been filed being aggrieved by the order dated 29/2025, by which the prayer of the petitioner for Zimma of the cash amount recovered from one Jamaluddin SK. Huh? Jamaluddin SK had been rejected on the ground that the ownership of the apparent of the seized amount was yet to be determined. Full stop. Issue notice. Call for
A report from the IO regarding the Zimma of the case.
Huh?
A report from the IO.
Call for the report from the IO regarding the seized cash money. List on
Matlab, fifth.
5th
Yes.
December, along with the report.
Made please, your Lordship.
Hmm.
Yeah, Lordship, I was absconder seated, Lordship. Yes, NDPS case, Lordship, by the investigation agency, Lordship. And thereafter, in the very first day, Lordship, by the special judge on 8/9/2025, issued NBW, Lordship.
Hmm.
And I will take part in the Lordship procedure before the trial court, Lordship. So, Lord, yes, given the reason that, Lordship, this court is of the view that page 22, Lordship, Annexure 3, it may not be possible to procure the attendance of the accused by issuing summons or BWL. Lordship.
Hmm.
Accordingly, issue NBW against the accused. So, I mean,
Charge sheet was submitted. Then what happened?
then, Lordship, this is the
When was charge sheet submitted?
charge sheet on, Lordship, 29/2025, Lord. This court has, this case has been registered, Lordship, before the trial court, Lordship.
29/8/2025.
Lordship,
Is it? And this order is of 8/9.
8/9. This is the very first day, Lordship, before the trial.
Matlab,
He was on bail.
Lordship?
He was on bail.
No, my lord.
No, he was
absconder
absconder.
seated, Lordship.
So
Observation of court is that matlab, this court is of the view that it may not be possible to procure the attendance of the accused by issuing summons or bailable warrant. So, actually, first summon,
not
then
the
bailable,
first.
then
Everyone, it should not happen.
steps will be summon, bailable warrant, and
We'll
BW,
keep this in abeyance till 7.
Next date is 18, Lordship. I have.
18th of
next-
December.
Lordship.
Next
Annexure
page.
4, page 22.
And then they will
We'll keep
appeal.
it in abeyance. Allow him to appear.
Yes,
Lordship, I will appeal, Lordship.
he will appeal, but remaining part, it will be decided by the court.
Huh?
Lordship. Okay, till then, at least the NDW may be kept in evidence.
This application has been filed under section 528, read with section 467 of the BNSS 2023, being aggrieved by the order dated 8/9/2025, passed by the special judge, Dhemaji in special NDPS case number 29 of 2025, full stop. The learned counsel appearing for the applicant has submitted that the charge sheet in the aforesaid case had been filed on 29/8/2025 and immediately on the first day when the court took up the matter, the learned special judge took a view that it may not be possible to procure the attendance of the accused by issuing summons or bailable warrants of arrest. Full stop. This view was based on the this view was taken because the accused public applicant hearing was shown as an absconder in the charge sheet by the investigating officer. Full stop. The next date fixed by the court was 7/11/2025, and on which date the learned court observed that the non-bailable warrants issued against him had not returned and fresh NBWA was issued against him. Full stop. The next date fixed is for 18/12/2025 for appearance of the applicant. Full stop. The learned counsel for the petition has submitted that in the circumstances, the applicant is under a reasonable apprehension that he may be arrested even before he would have a chance to put in his appearance before the learned trial court to face the trial. Full stop. Mr. A.K. Parashar, learned APP, has submitted that there would be no, it would be in the ends of justice if the petitioner is afforded one opportunity to appear before the learned special court on the next date fixed, since the non-bailable warrants were issued on the very first day without giving him any opportunity. Full stop. In view of the above, this court is inclined to stay the operation of the order dated 7/11/2025, by which fresh NBWs were issued against the accused applicant. Full stop. The accused applicant may appear before the learned trial court on or before 8/12/2025, on which day the learned trial court shall further consider the requirements of imposing conditions upon him to ensure his presence, his participation during the trial. Full stop. It is made clear that if the accused applicant fails to appear on or before 8/12/2025, the interim protection, the protection granted by this court shall automatically stand withdrawn.
Next date 18/12.
I said on or before 18/12. You can appear whenever you want before 18, on or before 18/12.
18, Lordship.
Whereupon the learned trial court will decide how to secure your further presence during the trial.
Lordship. Obliged, Lordship.
Disposed of. 17.
Yeah, okay. The 520 had application for quashing
Huh?
of the FIR, for quashing of the FIR, charge sheet and the entire proceedings, Your Lordship. The FIR, Your Lordship, at page 18. Your Lordship, the allegation herein is that I am the resident of the above mentioned address. My father's legacy number this is being used by another person, namely Safiqul Haq of village residence this. When he found out that I have submitted an application to the Honorable District Commissioner of the Sangadev Nagar Huja yesterday to investigate the legacy data, he has sent two unknown people last night at around 8 p.m. to find me and threaten me that if I investigate the legacy, they will kill me and my family. Therefore, they investigate the matter. The same was being registered under section 420, 468 and 506 IPC. Now, Lordship, the allegation that has been stated herein of using the legacy data, the Lordship will find at page 29. The legacy data that he has been alleged herein is the legacy data of his own father, Mahmood Ali, of the petitioner. At page 29, Your Lordship, the voter list serial number 338 of Dighal Jaroni. This is a place which is 6 kilometers apart from the Saharan, where the informant resides. And this is also a different village. Saharan is different village, Digal Jarni is a different village. He has alleged that we have used his legacy data, whereas this is his own legacy data, the petitioner's own legacy data, which proved by the other also. Your lordship may turn to page 33. The legacy data serial
That
number.
is something to be,
Ah, it has-
discussed
yes.
by the trial court.
Yes.
That is something to be discussed in the trial court.
How,
Which
matlab,
legacy data belongs to whom, which is whose
No,
voter
Lordship,
list.
this entire allegation is a false allegation against the petitioner.
be.
He is being wrongly harassed in this.
But will we sit here and try to find out which is a wrong allegation, which is the right allegation?
I have given every.
It is not perverse. See, the allegation is not perverse.
Yes.
Man has said that you have used his father's legacy data or his own legacy data. Whether it has been used or not is something of for an inquiry. Investigation has taken place. A charge sheet has come on record. Some allegation, some proof for the police that you are supposed to be tried.
But before this court, I have given every data.
participate in the
That is
investigation,
what you have to do in the trial.
participate in the investigation and.
Because this is, I swear in the name of God.
My
Your other person will come and say, I also swear in the name of God. You will prove what? Where will be the cross-examination take place? Then we have to make the election commission a party.
Yes,
They have to come and say that, yes, this is my voter list. Yes, this is of another person's voter list. Will we do that here? Ah,
It's up to the lordship because I have the allegation. We have come for the quashing of the FIR.
2019, charge sheet filed in.
It was filed in 2021.
What is the stage of the trial? Stage of trial?
Appearance stage, your lordship.
From 2021 onward.
Yes, lordship. On
Nothing
2012, 1/26, it has been fixed by appearance.
Huh?
This has been fixed by appearance in
Here,
2026.
proceed. Trial proceeds.
no, it has to.
This is a completely baseless
We'll take-
allegation, your lordship, and they have to face the trial without any reason. They have to go on bail. All the harassment they have to face. Because
That is,
I have
that
brought
is
into
something we
record.
cannot take cognizance of.
If
cognizance
required,
of.
your lordship will make an election party in this.
Why should we?
Matlab, in the
Why
criminal
should we?
petition,
You have
how,
made it
matlab,
there, huh?
criminal petition, we can,
Defense, huh?
criminal petition, how can this court examine
Petition, why are we examining all these things?
election commission?
What is your ground? What is wrong in taking the cognizance? Because this, what is wrong in proceeding with the trial?
We do not want to go for that trial because it will be another
You may not want to, but
harassment
you
for
have to.
the.
You may
petitioner
not want to,
because-
you have to. That is the only.
Because we have every proof to say that this is our own.
You understand? We have a good case for trial.
All the time his personal appearance is not necessary. Advocate will appear and all the time, matlab, you have to face the
to do?
trial, matlab.
What to do?
Lordship may call for the LCR if required. Your lordship will
Nothing.
take it.
LCR calling is putting
LCR
everything on
we
hold
have to
there.
verify
Everything
the
is on hold, out of court.
voter list and all this, we have to verify. How can it be, matlab? We have to
What
verify
will
all
we
this.
verify from the
We
LCR?
will verify.
Hmm?
The next day of listing, if your lordship may call for the LCR and look into the LCR, if anything can be find out to be quashed the.
Best of
entire-
them. Show us why we should interfere. Show us, or we are.
Because
closing
the
it.
documents that we have annexed herein clearly shows that he is the
We are not
father
to
of the.
appreciate evidence, sir. We are to see if it is perverse. We are to see if it is a case of no evidence. We are to see if there is a procedural irregularity. We are to see if there is an excess of jurisdiction.
And
Which of them?
if the prima facie we can prove in the case here.
Yes, what is the prima facie proof?
Your lordship may turn to the page 33.
Huh?
Herein also your lordship will find the mother name also. The mother's name also is a Safikun Nessa, and his mother name also is another Toirun Nessa. Then he has allegedly used another voter list, not Mui.
Best notice, but
Rather, it is the
burden the
informal-
court. Numbers will increase, nothing else.
Rather, it is the informant who has used the legacy
As
data
per the
of somebody else.
when charge sheet submitted, my lord, may peruse the page 24. Charge sheet, the remarks part, my lord, right hand column, my lord. During investigation, my lord. During it is found that the previous investigation officer report that the complainant was interrogated so and so and so, and witness statement recorded and attached so and so and so. And now,
Lordship, may
of the witness that the accused Shafiqul Haq, son of so and so and so and so and so Assam, whose name is mentioned in the FIR, was sufficiently involved in the offense under section this. Therefore, no, my lord,
how
on perusal of the on examining the witness charge sheet submitted, police. But to ascertain whose voter ID, who has used.
So, learned counsel appearing for the petition also,
Difficult.
the learned AP, Mr. KK Parashar, the learned counsel appearing. Learned, also had Mr. KK Parashar, learned APP, full stop. This petition has been filed invoking the inherent powers of this court for quashing of the FIR charge sheet and the entire proceedings in connection with PRC case number 1643 of 2024 under section 420/468/506 of the IPC. In connection with Murajhar PS case number so and so pending before the court of the learned CGM, Hojai, Assam, full stop. The learned counsel for the petitioner has submitted that the FIR had been lodged by the informant on false allegations in as much as the petitioner did not use the legacy data of any other person while submitting his application for
No, no application. They have said that we have used the legacy data. That is the allegation.
he had not used the legacy data of any other person, full stop. The FIR was lodged on 15/9/2029 and the case has been charge sheeted on 15/2/2019.
No, started on 2021. Yes.
Charge sheeted on 31/10/2021, full stop. The case is now at the trial stage, full stop. The learned counsel for the petition has submitted that it is now fixed on
12/01/26.
12/1/2026, full stop. On pointed queries, comma, the grounds on which the present application is sought to be premised on does not inspire the confidence of this court to interfere at the stage of trial in the present case, full stop. The grounds taken are with regard to the evidence which could be produced by the accused before the trial court to prove his defense, full stop. Since the case is still at this stage of appearance, comma, this court does not deem it fit to interfere in the trial process, full stop. Accordingly, this criminal petition, comma, being devoid of merit, is dismissed at the motion stage itself.
All right.
Yeah, please.
Yes.
Lordship, this is an application referred against the order dated 22/11/2024 passed by the learned court of Chief Judicial Magistrate at Tinsukia, Lordship. Now, Lordship, in this case, this is a matter which pertains to a negotiable instrument act case, Lordship. So after Lordship, the appearance of the accused when the trial commenced, thereupon the complainant was examined and cross-examined as per the mandates of law.
Mm.
Thereafter, the complainant side brought in PW2, who is the authorized representative of the bank. And during the cross-examination of the PW2, Lordship, there was an admission made by the PW2 whereby he stated that, yes, the bank documents which I have provided today before this honorable court is not admissible as per law since I have not produced a 65B certificate along with the same.
Mm.
Now, thereupon, Lordship, what has happened on that day itself, nothing as such occurred. And the next date was fixed for further evidence. But on the next date, Lordship, that is on 22/11/24,
Mm.
the complainant side preferred an application under 311 CRPC before the learned court and for recalling of the said witness, Lordship, and to produce the said 65B certificate, Lordship. Now, thereupon, Lordship, we raised our objection, but the learned court
You raise an objection.
objection to
I do
for
not think so.
recalling of the
Complainant is absent with steps.
yes, complainant.
So when was the objection?
No, I am for the accused, Lordship.
Accused, huh?
Yes, the petitioner is the accused, Lordship. So on that perspective, Lordship, may kindly peruse paragraph 25, Lordship, page 25 of the petition, Lordship. That is annexure 3, Lordship. That is the impugned order. Page 25, Lordship. If I may read, Lordship. Thus, in the facts of the present case, I am of the opinion that the decision of the Honorable Apex Court as referred by the engaged counsel for the complainant side is completely applicable, and the certificate under 65B of the Indian Evidence Act can be produced before this court at this stage as well, and the same will not prejudice the accused person in any ways, as the defense will get ample opportunity to cross-examine the concerned witness on the certificate under 65B of the Indian Evidence Act.
Mm.
Now, Lordship, now in our ground on this appeal is this, that whether such a procedural indulgence can be provided to an accused once, because considering that a case under Negotiable Instrument Act is of summary trial procedure, Lordship. Here the complainant had the liberty to produce the witnesses, produce the documents. Now this amounts to a pure filling up of the lacuna of the case, which is not permissible, Lordship, as per the law, as per the various decisions laid down by the Honorable Apex Court. That it can lacunas can fee level should not be used to fill in
There was
lacunas.
some law that if a certificate is not under section 65B is not produced, it cannot be allowed to be produced at a later stage by recalling the witnesses after giving you a due opportunity of cross-examination.
Lordship, I will
What
satisfy.
kind of a lacuna is being filled up?
Because, Lordship, being a complaint case, Lordship, it being a complaint case, it's the complainant who had the burden to produce those documents at the very onset, Lordship. Now, only when such a lacuna had come out during the time of cross-examination,
Ah.
when the admissibility of the said document only went out of question because they did not produce that certificate along with the exhibit. So thereby,
You made them wiser in the cross-examination.
Lordship, but-
Re-examination can be permitted. You made them wiser.
Lordship, that will be a precedent which will be basically giving an indulgence again. Because at their own whims and fancies, Lordship, at any point of time, they will come back and say, okay, this has been admitted and will.
Is it not permissible, Mr. Parashar?
That, we are not there in.
I understand, but just 65B was not given at the time of the
Technical issue,
examination.
yes. Technical issue, and case matlab.
Okay, notice.
Lordship, I also pray for an interim protection for stay of the trial at this moment, because Lordship, otherwise what
We will keep the re-examination and cross-examination, if any,
Lordship,
subject to outcome.
Lordship,
They will not be, we are not staying the process, let it
Lordship.
go on.
Lordship,
As early as possible, we decide this.
Lordship. That
And if by the time this division, this petition is not decided,
Lordship,
and the evidence comes to a conclusion,
Lordship,
inform the court, we'll take it up.
Lordship.
Decide before the arguments are to be placed in the lower court. Can that be done?
Very fair.
Why stay the entire process?
Very fair enough. Very fair enough. Lordship.
Let them come, because ultimately, if we decide that it can be allowed,
Lordship. Then we can.
that will be taken on record. If not allowed,
Then
whatever was there will be wiped out. It will remain at the stage of, at the end of the cross-examination of that particular PW.
Lordship.
The re-examination part will go.
Lordship.
Is it not?
Fair enough, Lordship.
Why should we stay?
Fair enough, Lordship.
This criminal petition and this criminal petition has been filed by the applicant being aggrieved by the order dated 22/11/2024. What has happened after this? Sir,
Lordship,
what has happened after this? It was fixed on 18/1/2025.
Lordship, actually what happened
Thereafter,
thereafter.
the re-examination was done.
No, it was not done, Lordship. Actually, what had happened, the court had, due to a maternity leave, had taken leave.
Ah,
And the case was again later on transferred to another JMFC court.
ah,
And the dates were in a very longer perspective. And as on date, today was a date fixed actually.
Hmm.
So whereby we have informed the court that the matter is fixed before this honorable court.
Hmm.
And will provide necessary orders as in.
or we can defer the re-examination of PW2 till the matter is decided.
Lordship,
The other evidence can go on. if
I
it is-
can go on, Lordship. We have no objection with that.
Okay.
Lordship.
Agreed by the order dated 22/11/2024. Passed by the court of the CGM, learned CGM, Tinsukia, in NI case number 137 of 2016, Counsel for the petition applicant has drawn the attention of this court to the order dated 22/11/2024, by which the learned trial court had allowed recall and re-examination of the branch manager of the Punjab National Bank to produce the certificate as required under Section 65B of the Indian Evidence Act 1862, which was not produced at the time of examination of the said PW. Stop. The learned counsel submits that when the said fact of non-production of 65B, a non-production of the certificate under as required under Section 65B of the Indian Evidence Act 1872 was pointed out during the cross-examination, an application had been preferred by the complainant to allowed to be recalled to be allowed to recall and re-examine the aforesaid witness. Full stop. Submits that such procedure would amount to filling up the lacuna in the evidence of the PW number 2 and therefore was not required to be allowed by the learned trial. Issue notice the respondent number 1 and 2 stop by speed post. The petitioner to take steps within a week from today. Is the matter again after 3 weeks on a date to be fixed after 4 weeks on a date to be fixed by the registry along with the service report. Is provided that that till the next date of listing, recall and re-examination of the PW number 2 shall be kept in abeyance. Further orders will be considered on the next date of listing. On a 4 weeks on a date to be fixed by registry, no reply list again on January DD of date. When is the next date fixed?
Today is the
Okay.
next.
On 27th of January. 27th of January. Huh?
I'm deeply obliged, Lordship.
Oh, Mr. Das, just adding one sentence. It's clarified that this court has not
Yes.
stayed the trial proceedings as such, and only the recall and re-examination of the PW number 2 would be kept in abeyance till the next date fixed.
Lordship, deeply obliged.
Yes,
My lord, the petitioner has come up against the NBWA issued against the petitioner, my lord. That is at page number 29. My lord, a case was registered against him under section 354 IPC and section 8 of POCSO Act in the year, my lord, 2023. Thereafter, absconding charge sheet was filed against him, my lord. He was unaware, my lord. I am ready to appear, my lord, surrender before the court. Till then, my lord, I may be protected.
Why absconding? Previously, during investigation?
My lord, the case of the petitioner is that he was always available in his house and locality. Police never searched him. And he was unaware because, my lord, it was basically a love affair, my lord. He thought that nothing will happen, and later on, my lord, the charge sheet has been laid before the court on 30/4/2025, my lord. Now he is willing to contest the case, my lord. Till the next date, my lord, some protection may be granted, my lord.
Yeah, got a decision to appear. Captain Evans.
Otherwise, he is the otherwise he is the main accused. matlab he is the-
Only accused.
No, but
He is the only.
let him appear on the next day. Trial court would look into it. At a দিছিল the NBW was kept.
Item 14
Captain
আছিল,
Evans allowing him to appear
আছিল item
till
14.
the and the trial court will. Okay, we'll keep it in abeyance till the next day. What is the next date?
And next date, my lord, 29/12, my
29/12.
lord.
Similar order passed in item 14.
Item 14.
Yes.
And you will appear any day before 20, on or before 29/12, upon which the learned trial court will look into
Lord.
the further conditions that will be imposed upon you to ensure your attendance during the trial. On failure, protection gone.
Lord. I am obliged.
Disposed.
Highly obliged.
21.
May please, your lordship. I'm challenging the order at page 17, my lord, for non-compliance of section 202 of CRPC, my lord. This is a mandatory provision of law, my lord, where the accused is residing outside the jurisdiction, my lord, territorial jurisdiction, is incumbent on the part of the court below, my lord, to have an inquiry under 202, my lord. I'm relying upon two judgments, my lord.
Tell us. Yes, what judgment?
Paragraph 3, 4, and 5, my lord.
Yes, sir.
Lordship, here, Lordship, may please to see the complaint was filed in the year 2019. In the meantime, Lordship, many summons were issued to him, but he didn't appear. Lordship, finding no, Lordship, may please to see the order at page 17. There is the complaint petition and materials on record, finding prima facie materials to exist cognizance of offense under section 276C, 277, read with section 278E of Income Tax Act is taken against the accused Murari Swami. Complaint is to take steps, issue summon to the accused for appearance. Next date was fixed for appearance. But see, thereafter also, till date, he didn't appear before the authority. Not please to see the complaint. What offense has been made against him? Page 12, Lords. The complaint was filed under the provision of IPC as well as Income Tax Act. Under trial court on being fined, prima facie fined, only the cognizance was taken under the Income Tax Act, Lords, not under IPC. Not see the mandatory provision in the income tax is that we have
Compliance of the provisions of section. compliance of the provisions of section 200.
Lordship, it was in taken, Lordship, in 2019 itself, notice was issued the PDC. It didn't appear. Lordship, ultimately in 2022, the cognizance was taken under the provisions of the Income Tax Act, Lordship. Lordship, please to see the aberrations in the complaint. Lordship, under section 280 of the Income Tax Act, we have to take approval of the commissioner, Lordship. For before filing of the complaint. That has been mentioned in paragraph 1.
That has been
Page-
taken. We have
Page
seen.
13. Yes, Lordship. Thereafter, Lordship, please to see the next paragraph. Paragraph 2, page 14. The SEC filed his return of income tax for the assessment year 2015-16 on 26/4/2016, declaring total income of rupees 2,66,400 under the head salary income. He has evaded the tax. He didn't disclose all these things, Lordship. This is the offense against him.
All said and done. The mandatory nature of 200.
No, Lordship, it is correct, Lordship, but Lordship, may please to see, listen to section 200, Lordship. And Lordship, may please to see, in 2019 complaint was filed. They woke up in 2025 only. And another 2 cases are also pending against the present petitioner, Lordship. (202). Postment of issue of process. Any magistrate on receipt of a complaint or an offence of which he has authorized to take cognizance or which he has been made over to him under section 192 may, if he thinks fit, sell in case where the accused is residing a place beyond the area in which the exercise is jurisdiction. Postponement of the issue of process against such accused and either inquire into the case himself or direct the investigation to be made by the police officer or by such persons as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding, provided that no such direction for issuance shall be made where it appears to magistrate that the offence complaint is of tribal exclusive by the court of session. 2, where the complaint has not been made by a court unless complainant or the witness present, if any, has been examined on oath under section 200. Then 2, in inquiry under subsection 1, magistrates may, if thinks fit, take evidence of the witnesses on oath, provided that appears that the magistrate at the offence of the complaint or is a tribal exclusive by the court of session, then it will not come. Then 3, if the investigation under subsection 1 is made by a person not being police officer, he shall have for the investigation. Lordship, here exception will come. Here the complainant is a government servant, Lordship. So he is exempted under section 200. Proviso, Lordship. Lordship, the materials placed before the court in 2019, Lordship, and cognizance was taken in 2022. Until date, he didn't appear. And in 2022, he got the notice, someone as reflected from the complaint. But for this last 3 years, 4 years, he didn't wake up, Lordship. Suddenly in 25, he woke up and
Yes, sir,
filed his
if
complaint.
this complaint is being made by a government servant,
Yes, Lordship, by the income tax office.
then show that he needs to be examined. Section 200 says, provided that when the complaint is made in writing, the magistrate need not examine the complainant and the witnesses if a public serving acting in the discharge of his official duty has made the complaint. This is for tax evasion.
Yes.
Made by a government servant.
My lord.
Need not be examined. Yes.
And furthermore, Lordship, the offences of income tax under the income tax act is compoundable, Lordship. Can avail this opportunity also before the officer, Lordship.
Yes, sir.
Lordship may take up on Monday, on this point I can satisfy Lordship, my lord. Because Lordship will see.
At the request of the learned counsel appearing for the petitioner, list this case again on
Lordship,
Monday.
On 8th, next week I'll be out of Guwahati.
On the 8th?
Hello.
On the 8th. Mr. So-and-so on the council paying for the petitioner, Mr. So-and-so paying for this.
Much obliged, Lord.
Much.
Met with your lordship.
Ah,
My lord, this is against the impugn order. Lordship will find page 38, my lord.
page 38.
Yes, lordship.
Yes.
The form. My lord, the opposite party number 2 filed a complaint, and on receipt of the complaint, my lord, the learned magistrate directly issued, my lord, notice to the petitioner, my lord,
Hmm,
which is contrary to the law, my lord.
which law?
Yes, my lord. Lordship may kindly see section 223 of BNSS, my lord.
Of?
BNSS.
220?
223, yes, my lord. There is a violation of two provisions, my lord. 223 as well as 225. May I read, my lord?
Hmm.
No.
Earlier 200.
Yes, my lord.
Earlier 200.
223.
Now you are on 223. Yes. So?
So, my lord, as per this provision,
Ah.
when magistrate receive a complaint, he
Ah.
should write the statement, he should take the statement of the complainant as well as witness,
Ah.
and thereafter reduce it in writing, and then, my lord, he may issue notice, man,
Hmm.
before taking cognizance.
Ah.
But there is no such, my lord, lordship may kindly see the order. Only peruse the seer, issue notice to the accused person, complainant shall take steps. And this date is fixed, my lord. And another reason, my lord, lordship may kindly see the address of the petitioner and the respondent number 2, my defender, opposite party number 2. My address is, my lord, district is Sivsagar. And the person, the complainant address is in Saraidev. So, learned Saraidev court, while taking, my lord, issue notice, he also derived from the provision of section 225, my lord.
Sorry?
My lord, the accused is a different district and the complainant is another district. The complaint which was filed
Hmm.
before the Saraidev is the accused is not within that district, my lord. It is a different. And when there is a different district taking, my lord, cognizance or notice, so there is a provision section 225. Lordship may kindly.
Cause and have an inquiry caused by the police
Yes, my lord.
or other competent authority.
Yes, my lord. There also, my lord, statement has to be recorded and thereafter that, my lord. And moreover, my lord, if your lordship goes to the complaint itself, so it is a case, my lord, where there is a live-in relation and thereafter, my lord, some dispute, legal notice issued, the opposite party replied, and then, my lord, he demanded by filing this complaint, my lord, sum of rupees so and so, I already received from him, my lord. So purely is a civil dispute, my lord, personal things.
Eh?
So personal nature, my lord. So I pray for lordship, you should notice meantime, my lord, this proceeding from either side, my lord, it is not.
Huh?
Lordship, may I stay the proceeding, my lord?
Yes. Examination
My
part.
lord, that
The
is
examination is
technical
not there.
part, my lord.
Yes.
Private complaint, है ना?
That is not, I'm a,
But Mr. Jiyuddin Leonard Council is paying for the petitioner also heard. The KK Parasar Leonard PP for the state, full stop. This petition has been filed selling the impugned order dated 22/10/2025 passed by the Learned Judicial Magistrate First Class Soraido in CR number 37 of 2025. Full stop. The learned counsel for the applicant has submitted that the litigation had been put in motion through a complaint filed by the complainant. Comma, who is arrayed as the respondent number 2 herein. On. What's the date of that filing?
My lord, this date is. You can,
One that gone,
yes, sir, from the affidavit portion.
1811, that.
Huh?
This
16th
complaint was
day of-
filed on 16th day of
15th day of October
October
2025, full stop. On receipt of the case record on transfer for disposal, the Judicial Magistrate First Class Saraido had issued notice upon the accused oblique applicant herein, requiring the complainant to take steps. Full stop. The learned counsel for the petition, huh?
thereafter another date is given. This matter on next date 17/12/2000.
The learned counsel for the applicant has submitted that the procedure envisaged in section 223 and section 225 of the BNSS, 2023 had not been complied with by the learned magistrate, and notices were issued without examination of the complainant and other witnesses on oath.
Yes.
Full stop. Further, the learned counsel has pointed out that both the complainant and the accused belong to different districts, and therefore the mandatory provisions of section 225 were also required to be followed, which were not followed. Stop. Issue notice on the respondent number 2 by speed post. Full stop. State of Assam is already represented by Mr. K.K. Parashar. Extra copies be furnished to him. List again on 28th of January 2025. Full stop. It has been submitted by the learned counsel appearing for the petitioner that the next date fixed is on.
My lord,
Next date fixed by the trial court is on
17/12/2025.
17/12/2025. Stop. In view of the assertion of non-compliance of the mandatory provisions of the BNSS, this court directs that further proceedings in CR number 37 of 2025 shall be kept in abeyance till the next date of listing. Further orders would be passed. When further orders would be passed.
Right.
Wait, please, your lordship. Allowed the case pertains to Jimma of a Artica vehicle. The the short narration of fact which is germane for this case is this, my lord. A truck container carrying some contraband was being intercepted. And the allegation is that in this vehicle, 5 persons were traveling in this vehicle who were escorting the truck. That's the allegation. No contraband whatsoever was recovered from the said truck. From the said vehicle, Artica vehicle, for which I'm filing this Jimma. Now, my lord, the petitioner he rents out car, and that's how he earns his livelihood. And these 3 persons who were found inside that Artica car, my lord, they have taken this vehicle on rent from Agartala to Guwahati. Be that as it may, my lord, all of them were arrested. All of them are on bail. While granting bail, your lordship will kindly come to page number 74 for a while.
74.
Yes. This is the order granting bail to the present petitioner.
Wow. Yes.
Para number 19. It is pertinent to note that nothing was recovered from the vehicle which was driven by the present petitioner. Now, my lord, I filed a Jimma petition before the learned court below.
You are the owner.
I am the owner of the that Artica vehicle, which I drive for to earn my livelihood. Now, my lord, I filed a Jimma petition before the learned court below. The learned court below said that NCB have submitted that this vehicle was escorting. So I presume that this perhaps might have some involvement. So I reject his Jimma. That's the reasoning that your lordship will find at page number 87, para 21 and 22. Though some other articles like PAN card and driving license and Aadhaar card, those were given on Jimma. But as far as the Artica vehicle is concerned, the prayer for Jimma was rejected. No reasoning whatsoever. NCB have made all this submission. So I
Page 80.
87, para 21. It is alleged that the Maruti Ertiga car was following the container truck in which ganja was transported. The container truck was destined to Bihar. Accordingly, the seized ganja truck was destined to Bihar. Accordingly, the seized ganja was also to be transported to Bihar. For such transportation, the accused person would have been paid. So we can assume that the Maruti car was escorting the container truck and was observing safe transportation of ganja from Tripura to Bihar, therefore rejected. Now the question is that, my lord, in a petition, my lord, under 451, the R12 CRPC 451 for this, my lord, for Jimma custody of interim custody of vehicle, my lord, that vehicle is lying under the open sky. That is a lifeless body. That in no way can make any statement, nothing, my lord. My lord, it is prejudicial both for the state and for the petitioner, in as much as the petitioner is losing his livelihood and the state will have to depute an additional place, an additional person to protect that property. Therefore, my lord, the Supreme Court, way back, your lordship is aware in that Gujarat and Ambala case said that normally you don't detain goods more than 15 days. That was the mandate. However, my lord, that judgment, my lord, some department they follow, some they do not follow, this sort of thing. Of very recently, my lord, the Supreme Court in an NDPS case said that there is no bar for granting interim Jimma in case of NDPS cases. Because there is, my lord, because the NDPS case is a special act, and unless there is any provision which is in contravention with the CRPC will prevail. So therefore, 451 CRPC, the Supreme Court says the court can give interim Jimma with an elaborate justification. If your lordship wishes, I can rely on both the judgments, my lord. Both. Because at the end of the day, my lord, this vehicle is not going to speak anything. It's simply lying, my lord. It is serving nobody's cause.
And it will also not escort any other truck.
My lord, it will definitely escort, but then not truck containing this.
Yes, what were you trying
Now,
to do?
yes, your lordship will first take up this 2002, this 10 SCC, the thin one. Your lordship may come to para 17 and 21. I'm just relying on 2 paragraphs. My lord is there at internal page 289. In our view, whatever be the situation, it is of no use to keep such seized vehicle at the police station for a long period. It is for the magistrate to pass appropriate order immediately by taking appropriate bond and guarantee as well as security for return of the said vehicle. If required at any point of time, this can be done pending hearing of application for return of such vehicle. Even the Supreme Court says even pending application for Jimma, you can grant. Pending application for Jimma as an interim measure, and para 21, an outer limit sort of indication the Supreme Court gives at para 21. My lord is there. However, these powers are to be exercised by the magistrate concerned. We hope and trust that the magistrate concerned would take immediate action for seeking that powers under 451 CRPC are properly and promptly exercised and articles are not kept for a long time at the police station in any case for not more than 15 days to 1 month. This observation, this object can also be achieved if there is proper supervision by the registry of the High Court concerned in seeing that the rules framed by the High Court with regard to such articles are implemented properly. Now, my lord, these being the law laid down by the Supreme Court, my lord, now the seizure in this case was effectuated somewhere in the year 2023. So 15 days, my lord, 15 months, more than 15 months, in fact. Now, your lordship will take up the recent judgment of 2025 3 SCC 241. Now, my lord, para 26 for a while.
You were traveling in the Artiga.
I was driving the Artiga, in fact.
You were the owner and the driver of the Artiga.
Of the Artiga.
Nothing recovered from there.
No.
Truck was carrying the contraband. You do not know the truck.
Yes.
You were simply following it.
As per allegation, yes.
That is your story. You were following it in due course. There was a vehicle in front of you. You were going behind it.
Otherwise, also one vehicle will always follow the other, my lord, in a national highway.
Yes.
And that para 26 and 27, my lord, that NDPS Act, no exception is carved out with respect to interim Jimma of vehicles.
Yes, sir.
Lordship, first I want to place my objection, we file objection. That was called, Lordship, paragraph 3.
P.
Lordship.
Yes.
That is, Lordship, technical objection was taken because wrong case has been mentioned. Lord, that is not so important, Lordship.
Typographical error, my lord.
Paragraph 8.
8.
There is a statement in paragraph 3 to the extent that they narrated the prosecution case in seizure of 517 kgs of ganja from the container truck and a reference to Ertiga car are matter of record. However, the attempt of the petitioner to dilute his involvement is denied. The complainant clearly shows that the Ertiga car was following and escorting the truck carrying commercial quantity of ganja, and the petitioner was knowingly accompanied the consignment. Then paragraph 9. It is submitted that the Ertiga vehicle, its initiation key and registration documents were seized not as innocent article, but because the vehicle was a tool of commission of offense consciously used by the petitioner and co-accused. The Lordship may come to page 82 of the bail application, where our objection was filed and it was considered by the learned court. Lordship may come to paragraph 19, page 86.
Paragraph 19.
Lordship.
Period that.
Page 86.
It is prayed
It is
that.
prayed that the to reject the, it was a submission of the NCB. Then 20 peruse the record 21. It is alleged that Maruti car was following the container truck in which the ganja was transported. The container truck was destined to Bihar. Accordingly, the seized ganja was also to be transported to Bihar. For such transportation, the accused persons would have been paid. So we can assume that the Maruti car was escorting the container truck and was observing safe transportation of ganja from Tripura to Bihar. Then paragraph 22. In view of the above facts and circumstances of the case, this court is of the considered opinion that the Maruti Ertiga vehicle being used for safe transportation of the seized ganja should not be given in custody to its.
Just tell us. You keeping the truck somewhere? That Maruti Ertiga car somewhere?
Lordship.
How does it help either your investigation or the prosecution?
Lordship, for the trial, it is necessary.
What?
Lordship may come to page section 60, subpara 3 of NDPS Act, Lord. Because here, Lordship, the petitioner is also accused in the case.
Yes.
Paragraph, section 60, subpara 3. any animal or conveyance used in carrying any narcotic drug or psychotic substance or controlled substance or any article liable to be confiscated under subsection 1 or subsection 2 shall liable to be confiscated unless the owner of the animal or conveyance prove that was used without his knowledge or connivance of the owner himself, his agent, if any such person in charge of the animal conveyance, and that each of them has taken all reasonable persecution against use. Lordship, here the petitioner is accused in the case also, Lordship. So section 63 bars,
Then we will read it again.
Lordship.
Any animal or conveyance used in carrying the narcotic.
Lordship, here, Lordship, may I please to see that last 4 lines of subsection, this subsection, Lordship.
Ah.
So
Is
used
liable
without
to
his
con-
knowledge.
Hmm?
Without his knowledge. Here, Lordship, it is learned trial court has also come to a finding.
That vehicle should be used to convey it.
Yes, Lordship. Here, yes, it was not carrying but it was following the truck and facilitating
So,
transporting the goods, Lordship.
so subsection 3 does not come into play.
Lordship, in my humble submission, it will come into play
How?
because he is accused in this case
Yes.
also. And Lordship,
Any animal or conveyance used in carrying the narcotic drug or psychotropic substance, it does not say the accused.
no, Lordship.
Otherwise also section 60 will not come. It is after the conclusion of trial.
No, Lordship.
Interruptions. Yes.
Lordship, the title of the section is liability of illicit drug, substance, plant, articles, and conveyance to confiscation, Lordship. Here, Lordship, that learned trial court has come to a finding that since the truck was Maruti Ertiga was facilitating the truck which carrying the narcotic drugs, he was following that, Lordship, and he is himself an accused. That's why this honorable court, after considering this, Lordship, whatever it granted bail to him, but he is an accused. With condition he has been granted bail, Lordship.
So he can be out, but the car cannot be.
Lordship.
He can be outside, the car
But
cannot
Lordship, with condition, Lordship, he has been granted bail.
be. With conditions, the car will be out.
Not that definitely that will follow, Lordship. This is my humble submission, Lordship. Definitely, Lordship, if
You can
Lordship,
record all your objections,
Lordship,
but suppose the vehicle is kept there, it takes 4, 5 years, 6 years, 7 years. This is not a vehicle carrying the contraband. You would not be required to demonstrate that it was in this part of the car that the contraband was being.
that is there, Lordship.
While we disagree totally with him, he has not given any document in the file to show that it was a commercial vehicle which would earn his livelihood.
That, Lordship,
It is
That may
another
be
issue, but
correct statement.
can it be taken? Can it be kept in a field
But Lordship, in
waiting for it to rot away?
recent judgment, Supreme Court says, yes, 451 is applicable in case of NDPS also. But Supreme Court says that if there is involvement of the truck or vehicle, then it should not be released.
Let
That
us
is,
read that part again,
yes.
2025,
yes, Lordship, it is mandated.
7th of January. Are we on Vishwajit Day?
Yes, Lordship.
Firstly, where the owner of the vehicle is the person from whom the possession of the contraband drugs is recovered. Nothing recovered from him.
Yes, that is correct, Lordship. That-
Contraband is recovered from the possession of the agent of the owner, not the allegation herein. Vehicle has been stolen by the accused and contraband is recovered from such stolen vehicle, not the case.
No, it is, but
Then-
Lordship, Supreme Court says that if there is involvement of accused person along with that,
Where?
yes, Lord.
Towards that line.
Yes,
Give us
I'm-
that sentence.
I'll show, Lordship.
We would like the government to take care of the vehicle.
Yes, it is there, Lordship.
Which stands there, the government will take care, and once everything is over,
Then
will return it to him in a condition in which it was confiscated. Can you do that?
But in case of NDPS, Lordship, the situation is different, Lordship.
Yes.
For the first time,
We
Supreme
will
Court
take
say,
all, we should take all precautions to see that menace is stopped. Things are not reused.
that is, Lordship, normally these things are there. We cannot deny that. But for the first time, Supreme Court says that in case of NDPS, section 451 and 452 will be applicable.
NDPS, if that vehicle had carried any substance,
No, that is, Lordship,
if
but
the accused was found in possession of any substance,
no, that is
definitely
there.
we would have
But
taken a
it-
different
it is-
view.
It is admitted, Lordship, nothing was recovered from the Maruti Ertiga.
Hmm.
It was followed followed by the truck was followed by them, Lordship, including the petitioner. He was also involved. And his statement was also recorded under section 67, Lords. That is a matter of trial, whether it will be proved or not.
Yes, what to do, Mr.
Then paragraph 12,
Biswas?
my objection also may be.
Using a private vehicle for commercial transaction.
My lord. My lord, that section 60, that confiscation part, my lord, why I intervened because I wanted to save time of the court. That section 60 business will come after conclusion of the trial, not now. And that is not what Mr. Biswas is submitting. Your lordship may see that judgment para 25, it is clear. Para 25 of the judgment. Upon reading of the NDPS Act, this court is of the view that the seized vehicle can be confiscated by the trial court only on conclusion of the trial.
I was also thinking.
Yes, it cannot be. That is one. Therefore,
Because seizure is one part and confiscation is another.
That is Lordship under
So
section.
how does 60 come?
60 will never come.
Once found guilty, once found an involvement, he will deposit the vehicle, they will confiscate it.
Absolutely.
No, that
At
is,
this stage,
Absolutely. That is what my lord I am submitting.
you are making us read a section which is not applicable in the present
the
case.
objection may be recorded, Lordship may pass in.
Regarding saying that it is liable to be confiscated at a stage when the trial is not yet proceeded.
Lordship,
Should we record that?
I have not, yes, Lordship may record it. Yes, Lord.
We'll record that. Heard Mr. M. Biswas, learned counsel appearing for the petitioner. Also heard Mr. S.C. Kyal, learned counsel appearing for the, learned special counsel appearing for the NCB.
Lordship.
Full stop. This petition under section 528 of the BNSS 2023 has been filed. Appearing for Zimma of the Maruti Ertiga car. Hearing registration number so-and-so, chassis number so-and-so, along with the ignition key of the Maruti Ertiga of the said car, full stop. The car had been seized in connection with NDPS case number 36 of 2023 corresponding to NCB crime number 28 of 2021 under section 20 within bracket B within bracket 2 Roman Tukholu within bracket capital C oblique 28 oblique 29 of the NDPS Act 1985 comma pending before the learned additional session judge number 5 Kamrup Metro Guwahati, full stop. Mr. Biswas, learned counsel appearing for the applicant has submitted that the petitioner herein had been arrested in connection with the aforesaid case and has been granted bail by an order of the
Honorable High Court.
Honorable High of this court passed on dash in DA number dash.
Page 69.
Page 60.
69.
Passed on
17/2/2025.
in BA number
2437 stroke 2024.
2024, full stop. The petitioner had moved an application claiming for Zimma of where is the description of your
First title, your lordship.
Deb Rubel Paul? Deb Rubel Paul. With regard to the Maruti Ertiga car described here, mentioned herein before, and by the order dated 23/7/2025, the prayer for Zimma had been rejected by the additional session judge number 5, Kamrup Metro, Guwahati, full stop. The learned counsel has drawn the attention of this court to paragraph 21 of the order dated 23/7/2025 to submit that the Zimma of the aforesaid car had been rejected only on an assumption that the car was escorting the container truck and was observing safe transportation of ganja from Tripura to Bihar. Full stop. The learned counsel for the petitioner has submitted that in view of the judgment of the apex court in Sundarbhai Ambalal Desai. This is number 1, huh? Reported as so and so, comma. It was held that it is of no use to keep seized vehicle at the police station for a long period, and it would be for the magistrate to pass appropriate orders immediately by taking appropriate bond and guarantee, as well as security for return of the said vehicle if required at any point of time, full stop. This can be done pending hearing of applications of for return of such vehicles also, full stop. The apex court had also observed that the application seeking Zimma of vehicles should be decided promptly to ensure that articles are not kept for a long time at the police station and in any case more than 15 days to 1 month, full stop. The learned counsel submits that though this was not a case under the NDPS Act, still, however, it remains a settled position of law that the vehicles seized in connection with criminal offences can be considered for release on Zimma, depending upon the facts and circumstances of the case. Full stop. The learned counsel has also referred to the case of Bishwajit Dev versus State of Assam, reported in where he has referred to paragraph 33 and which other para you were referring to?
I'm referring to 26,
26.
27. 26 would do, man.
26 and 33. To impress upon this court that even in case of vehicles seized in connection with offences under the NDPS Act, there is no specific bar or restriction or return of any seized vehicle used for transporting narcotic, drug and psychotropic substances in the interim pending disposal of the criminal case, full stop. The learned counsel for the petitioner has submitted that in the present case, the vehicle of which Zimma had been sought was not used either in the transport of any contraband substance, nor was any such contraband substance recovered from either the vehicle or the accused or the owner of the vehicle, comma, who is the applicant herein and who is also an accused in the case, full stop. Mr. SCK Learned Counsel, appearing for the NCB, has drawn the attention of this court to section 60 of the NDPS Act 1985 to impress that as per subsection 3, any animal or conveyance used in carrying any narcotic drug or psychotropic substance or any article liable to confiscation under subsection 1 or subsection 2 shall be liable to confiscation unless the owner of the animal or conveyance proves that it was so used without the knowledge or connivance of the owner himself, his agent, if any, and the person in charge of the animal or conveyance, and that each of them had taken all reasonable precautions against such use. Full stop. The Learned Counsel has submitted that in case the vehicle is now allowed to be taken away on Zimma, it may hamper the trial since the vehicle may be required to be produced during the trial proceedings, and also in case the vehicle is found to be involved in the alleged offenses, it would be required to be confiscated. So he has therefore prayed that the prayer made in the present application be rejected. Full stop. The Learned Counsel has also referred to the stand taken in the written objections filed on behalf of the NCB/Union of India. Full stop. We have, and this court has gone through the provisions of Section 60 of the NDPS Act 1985 and is of the considered opinion that the provisions of the said section does not provide any bar or restriction or consideration of release of vehicles on Zimma to the owners of vehicles, in cases where the vehicles are suspected to be involved in illicit trade of contraband substances. Where does it say that it is only after the trial?
Para 25 of that judgment of this Bishwajit De.
The Honorable Apex Court, in the case of Biswajit De Supra, has observed that even where the court is of the view that the vehicle is liable for confiscation, it must give an opportunity of hearing to the person. That the seized vehicle can be confiscated by the trial court only on conclusion of the trial. Full stop. Next para. The vehicle had been seized on
Seizure list has been seized on 26/9/2022.
2022, and the charge sheet had been filed on
Charge sheet offense report, page 11. Page 11 is the offense report filed on. Last page, 21/3/2023.
Full stop. The trial is proceeding in the matter. Full stop. The vehicle has been kept unused for a long time, and full stop. In view of the observations made by the court in Biswajit De and Sundarbhai Ambalal Desai, this court is of the considered opinion that the owner of the vehicle, namely the applicant herein, can be allowed to take Zimma of the vehicle, of the Maruti Ertiga vehicle bearing registration number so and so, and chassis number so and so, along with the ignition key to the said vehicle by
What's the paragraph, last paragraph of Biswajit De, condition has been.
what does it say? Hmm. By what is the usual bond to be given? The rest we will do it.
Lordship,
The usual bond.
that is, Lordship, that is, condition has been provided in paragraph, last paragraph, Lordship.
No,
My
the
lord.
bond part is suppose. Yes,
On execution of a bond of,
an execution of bond of rupees.
an execution of a bond of rupees.
Rupees?
The satisfaction
2
of the
lakhs.
IO, Lordship.
Of rupees 50,000
No, Lordship, because the value of that
vehicle.
vehicle is to be ascertained.
It is a vehicle of when?
That has-
Vehicle,
That has not been ascertained, Lord. Probably in Caesar list, it may be there.
Caesar list, lordship.
Caesar
will
list.
see.
The Caesar list, the make is not there.
Yes,
I had tried
Caesar
to
list
go
at page, बोला वो page को निकाल के रख।
The
60,
make is not there.
Ah.
That's the problem.
67.
Of rupees, so 1 lakh. I will. To the satisfaction of the
IO,
alternate trial court
No, my lord.
IO, Lordship.
of the IO. They are going for bill of the IO. Full stop. Further. The
Will not sell the vehicle, that
the
condition.
IO shall also retain video and still photographs of the vehicle, and after obtaining all information and documents necessary for the identification of the vehicle, the full stop, the applicant shall not sell or part with the ownership of the vehicle till conclusion of the trial, and shall also furnish an undertaking to the trial court that he shall surrender the vehicle within a week of being so directed. Or here they have said pay the value of the vehicle determined according to income tax.
No, my lord, those may not, because my lord, so many.
So
Jima
if so
petition were-
ultimately directed by the court.
Yes, Lordship.
My lord, only one condition, only one thing, my lord. Along with this Jima vehicle, your lordship may add, and the ignition key there.
That is what I've said.
Ignition
I've
key-
said no ignition. I've said yes. Along with
Without,
the ignition.
without key, how will operate the track?
No, because
The vehicle.
no, because they have my lord, this NCB key.
Without being in the track.
Lordship.
My lord,
The very manner in which,
the NCB crime number is in fact 21/2022. There is some traffic that may be inserted.
Did we not say that?
Because
In initial stage, Lordship has stated all these things.
no.
Lordship has stated all these things.
No.
Correct,
But
no?
your lordship have stated, actually it is my fault, my lord, because it was inadvertently, there was some typographical error. Which is,
Oh, 28. You have written 28.
yes, it should have been NCB crime number
21.
21/2022.
What you pointed out at
Yes,
paragraph 3.
yes. Lordship.
We quoted from his cost title. Therefore,
Yes.
this
That will be
28, he
corrected.
wants a correction to 21. No difficulty. Please post it.
I'm so deeply obliged.
2. Thank you. Endowed the capacity of the financial capacity of the petitioner to afford maintenance to his wife and the child. Full stop. Issue notice since Mr. K.K. Parashar here, learned APP appears for the state of Assam, extra no formal notice is required. The respondent number 1, however, extra copies within a period of 3 working days, full stop. Notice on the respondent number 2 by speed post within a period of 7 days from today, full stop. Petitioner at liberty to bring on record certified copies of the evidence led by the petitioner laid in the trial court for further consideration. Full stop. Next line. List on. When do you want it? 29th of January, 20. List on 29th of January 2025 along with the service report on respondent number 2. Full stop. Since it is available from records that the petitioner is drawing an amount of approximately 16,000 odd. What does he now get in hand?
In hand is lordship 54,457.
No. All that of is cut off, and what does it remain? What does it remain? What does it remain with? What does it remain with?
It remains with lordship around 13,000. 13,000.
With around rupees 13,000 after deduction of the loan amount, this court directs that during pendency of this petition, the petitioner would be required to pay maintenance of rupees 5,000 to the wife, public respondent number 2, and rupees 3,000 to the daughter. Full stop. It is clarified that the aforesaid order has aforesaid reduction in the payment is not passed on the merit of the case, but only keeping in view the fact that the petitioner as of now may not be in a position to pay rupees 15,000 when his on-hand salary after deduction of the liability stands at
Rupees 30,000.
an amount lower than what has been ordered by the trial court, full stop, learned trial court, full stop. The final, yes, list on as
29.
Grateful, man.
May I please, your lordship? This petition, lordship, quashing of the orders dated lordship 18/9/2025 in CR case number 4120. This is the NI Act, lordship. The order passed by the learned court below very 53 page number, lordship. Orders passed by all orders are enclosed here with lordship. All orders unanimously passed.
do you want to interfere?
NBW and PNA.
Why?
Lordship 53 page number. This is the cognizance. 5421 is. Can I read, lordship? This is very
You can read
surprising.
56 directly.
54, lordship.
Oh. 54.
Lordship.
Okay.
And it's a 21. May I read, lordship?
Yes.
30/12/2022. TM is on leave, lordship. Complaint is present and has furnished the track consignment postal receipt which reflect that someone was not served as no such person could be found in that area accused absent, hence NPW. Directly, lordship.
Yes. From when has this 4%
I have not
started
received
being issued available warrants?
My lord.
Who is he?
And TM is also leave.
TM is on leave.
Leave.
See the next page, page
Lordship,
55.
particular lordship, see, page number 55, signed by 4 judicial magistrates, first class, Kamum Metro, Guwahati. Particular.
List on is one thing. Sent to another court is one thing.
TM is transferred.
PW.
All
And
of
we
this from here, that means.
Huh?
I am a proprietor
And
of
on the next
partnership of
date-
6 years old. Amount is 2 lakhs only. I have not received any summon, warrants or nothing.
Just a minute. On the next date,
Next day,
judicial
27 court.
magistrate says PWA has returned back unserved, unexecuted.
Unexecuted.
He also does not notice that I never issued it.
My lord, in that occasion, my lord, 27/4, accused is absent with state. On that day he appeared.
Not a PSA, just file a Hagia someone.
Which step?
But directed to the petitioner, file a Bhokolat Nama. Not no.
Which step, my lord? That is line is there, my lord.
Someone file a Hagia, maybe.
One appeared.
My lord. Someone appeared.
Let us assume this is
Oh.
correct.
Right.
No interference.
Sorry, sir.
It is only this week we are saying no interference. Next week onwards, we will not give audience.
Lord.
So someone appeared,
Hmm.
but the BWA is unexecuted.
No report is
Then
there.
there is a direction, file your wakalatnama.
Hmm.
Then what happens on the next step?
Uh,
He is absent.
Absent.
So issue NWA. Which step? So NWA. When will you appear?
Next date is 25 on or before 25. Lordship petitioner allowed to appear before the court and file a appropriate application for.
And from 23
my lord,
onwards,
22 onwards, my lord,
only
he is
you have
absent.
the time to come to this court.
My lord. That
Huh?
is proclamation was on 26/9,
26/9.
24. From 2022, my lord, he is absent till 2025.
And address
Persons
was
who execute it
My lord.
have changed.
My lord. That's
Now the hurry. Huh?
Lord.
Is it so?
yes, per my lord, page 60, my lord, next date was 26/11.
Already passed.
Already-
Next day is
already
25.
Next date?
25 March.
When did you file this? When did you file this? Yesterday?
Not yesterday, Lordship, 21/11.
21/11. What happened on 26?
Lordship, we learned it. Honorable judge was illness, Lordship.
Huh?
Honorable judge was
Or did not
illness
sit?
and
But we'll give you an opportunity to
No.
appear.
appeal, Lordship.
What is the next date given?
25 March 2026.
Of March to.
On or before, Lordship?
Mm.
But court below will consider, my lord, their
Huh?
prayer. Court below will consider their
Huh,
prayer,
huh,
my
huh.
lord. That part.
এতিয়া অৰ্ডাৰ কেইটা দিছিল না কোড বিলো কনসিডাৰ কৰিব বুলি
14,
Thank you,
March
Akbar.
14 and
The
14. আগতে
this application has been filed. The section
Okay,
528 of the BNSS 2023 praying for setting aside and quashing the
It is
order
14.
dated 18/9/2025 passed in CR case number 4120 in a report C2 prescript /2022 passed by the Learned Judicial Magistrate First Class Kamrup Metro Guwahati, by which warrant of arrests along with the proclamation and attachment order has been passed. Full stop. The first order
30/12/2022.
on record in this case by which BWA had been issued
On
is of 30/12/2022, on which date the learned TM was on leave and the complainant was present and the accused was found absent. Full stop. A signature is available at page 55, which shows that someone or the judicial magistrate had issued the bailable warrant of arrest of rupees 2,000 against the accused / applicant herein. Full
Bench
stop.
assistant part.
Mhm.
Paras bench assistant pass the order. I mean,
Could it
court
not be
master.
taken up
Court master. No,
at some level?
no, my lord, my lord.
Huh?
That could not.
In the on the following dates, on the following dates, That is on 27/4/2023, comma. The petitioner has been shown to be absent with steps and the prayer was also shown to be allowed, comma, requiring the learned counsel to file wakalatnama on the next date fixed, full stop. On 7/6/2023, the learned TM is shown to be transferred and the in-charge judicial magistrate had issued NBWA against the accused, full stop. By the last order made available on record by the petitioner dated 18/2025, the complainant was required to take first steps for issuing NBWA along with P&A against the accused within 2 days, full stop. The next date fixed was for 26/11/2025, full stop. The learned counsel for the petitioner has stated that the next date now fixed is on 25th of March 2026, full stop. We have gone through the records next to the repetition, to the criminal petition and criminal revision, criminal petition, and also heard the learned APP appearing for the state, full stop. This court finds that the ends of justice would be met if the non-bailable warrant and the proclamation and attachment orders passed on 18/9/2025 and on 26/11/2025, comma, if any, are kept in abeyance till 26th of March 2026. What date? 26th? 26th of March. 25th of March 2026, comma, to give the petitioner hearing an opportunity to appear before the learned trial court on or before the said date, full stop. On his appearance before the learned trial court, comma, on his appearance, comma, the learned trial court shall decide on the requirement of conditions to be imposed upon the petitioner to ensure his presence / participation in the trial proceedings, full stop. It is made clear that in the absence, on the failure of the petitioner to appear before the learned trial court on or before 25/3/2026, comma, the protection granted by this court shall automatically stand withdrawn without further reference. Criminal petition disposed of.
Mass of blinded.
The learned trial court shall decide imposition of conditions, position of such conditions, such conditions.
Please, my lord. But I am also against an order issuing NBW, my lord. The order is at page number 19, my lord.
Page number 19.
19, my lord. 9/5/2025, my lord. 9/5/2025. The second order, my lord. PO was in leave, my lord. I went, my counsel told me that court is not there and this order has been passed, my lord. Subsequently, police came to my residence, then I acquired the knowledge. I have immediately come before the honorable court in acquiring knowledge.
So on 9/5, you did not, when your counsel told me that PO is on leave, therefore you did not try to find out 2/6 what happened.
He told me that he need not appear, the court is on leave. I went back, my lord.
And then next day you did not try to find
No,
out.
my lord, unfortunately, no. I was not informed also, my lord. It is only when the police came to my residence, then I got to know that NBW has been issued, my lord, against me.
What is the next date fixed?
My lord, it's tomorrow, my lord.
Tomorrow.
Yes, my lord. Therefore, it was listed yesterday also, my lord, before Justice Jahan, my lord, but she is not there. I again mentioned it before another bench, my lord. Then it was listed today, my lord.
Yes, let him appear to
My lord,
for a day.
My lord.
But evidence are already complete, no?
Evidence of the prosecution is complete. My evidence is yet to be adduced, my lord.
DW.
Whatever be the stage. Whatever be the stage.
My lord, no.
We'll allow him to appear.
Fine.
Don't appear tomorrow, then.
I'll appear, my lord.
Again.
Even if the PO is on leave.
My lord, I'll make sure that, my lord,
Application under section Iman. With regard to other consequential orders. This is an application filed under section 528, praying for setting aside the order dated 9/5/25. And other consequential orders passed in special POXO case number 21 within bracket N of 2023. Pending before the additional session judge, some special judge POXO, Nagaon, Assam, full stop. Although the learned counsel for the petitioner has submitted that although the presiding officer of the trial court was on leave on 9/5/2025, non-bailable warrants of arrest were issued against the petitioner due to his non-appearance, full stop. The learned counsel for the petitioner submits that it was on a mistake of information that he did not appear on the said date. And only recently when the police have visited his premises that he has come to know that non-bailable warrant of arrest have been issued against him and are awaiting execution, full stop. The learned counsel for the petitioner submits that the next date fixed for the case is 29/11/2025, that is tomorrow. And the petitioner is ready to appear before the court, learned trial court, to adduce defense evidence since the prosecution evidence is already closed. Full stop. Keeping in view the submissions made, this court directs that the NBW issued against the petitioner shall remain in abeyance till tomorrow, that is 29/11/2025, allowing the petitioner to appear before the learned trial court, full stop. On his appearance, the learned trial court may decide the requirement of conditions that may be required to be imposed upon the petitioner to ensure his presence and participation further in the trial proceedings, full stop. Petition disposed of. It is made clear that in the case, in the event of the petitioner failing to appear tomorrow, the protection granted by this court shall automatically stand withdrawn without further reference.
Deeply obliged.
May I please, your lordship? Lordship, we are awaiting instructions in this matter.
May I please, your lordship?
We need further time, that lordship.
But instruction is not required because lordship, and kindly come to page number 21, the order of passed by the learned court below, lordship.
Page number
21, lordship. 21. Lordship, here in this case, an operating person, lordship, page number 22. First para. Dear lordship, lordship, I have carefully considered the submission of both the sides. The fact remains that the vehicle in question was used to commission for serious offense and involving the counter currency of high value. The petitioner's contradictory stance regarding his ownership of possession. But I have already 2 times, lordship, notice has been submitted by the custom, lordship, and I appeared, lordship, and my statement has been recorded. And I have the copy also, lordship. And there is nothing, lordship, contradictory statement that because vehicle is belonging to me, lordship. And lordship, after hire purchase this vehicle, lordship, I could not provide the EMI. That is why, lordship, I have mortgaged my vehicle to one Mofidul Islam. And I have annexed, lordship, the mortgage deed, lordship.
During examination under section 108 of the Customs Act.
Customs Act, lordship. And thrice I was appeared to the.
Wait, show us the, have you given the evidence here? Your statements, have you given them here?
Yes, lordship. Yes. No, lordship. But subsequently provide, lordship, these are not the certified copy. That is why, lordship. Officially provides me after recording my statement. Lordship. Yeah.
You try to say that you did not deny ownership.
No, lordship, I am the owner, lordship. But in the meantime, at the time of seizing this vehicle, lordship, and prior to seizing, lordship, one Mofidul Islam.
Yes, where is your statement under section
108?
108 recorded?
Lordship, it is not lordship, it is not provided. Also, lordship, in the initial investigation period, on contradicting submissions were given by the petitioner lordship. Hence, we need further time to obtain instruction regarding that lordship.
That I was appeared and thrice.
And he is the owner of the car lordship.
Yes.
And
The only reason was that, the only reason for rejecting the Zimma is that he is giving contradictory statements.
Your lordship, lordship,
So, where is this customs office?
Kamrup Metro only lordship.
Huh?
Kamrup Metro.
it is
short
from
period
Silchar Kasar lordship. This case is registered in Silchar Kasar.
Huh? From where these 108 statements have to come from? Which office?
Kachar lordship.
Kachar. Total of maybe 20 minutes to
Lordship.
scan and send it to you that this is the 108 statement. The fun is in holding back the vehicle.
Lordship may fix this next week, lordship. Short date may be fixed, lordship. Short date may be fixed.
For a moment, lordship, for appreciate, kindly page number 17. There is nothing, lordship, at the time of.
Huh?
This is the vehicle, lordship. I was not there, and my vehicle already been mortgaged to one Mofidul Islam, lordship. Page number 17. And prior to incident, about 6 months earlier, lordship.
Mortgage to one Mofidul Islam because
Lordship, due to my financial problem, lordship, and prior to incident, about 6 months ago, lordship. And at the time of seizing, lordship, I was not there, and whatever is fake currency was there, totally I'm unaware, lordship.
Lordship, there is a possibility of his involvement, hence we need the instruction.
very few. In the first half, we have recorded even in NDPS case. The vehicle,
Yes, lordship, and
retention of the vehicle may not be so necessary. List again on the 3rd of December 2025, allowing the Customs Department to bring on record their stand regarding the contents of the criminal revision petition.
another prayer, lordship, if permit, lordship, I may be submit this by additional affidavit. Then
There
because
is
we
no
have-
bar.
Lordship,
There is no bar.
lordship. Obliged, lordship, obliged, deeply obliged.
Yes, sir.
May I please your lordships. This is since long pending, my lord, and my lord, both
Long
the
pending.
petitioners are in jail, my lord, since long, my lord, is a 480 days, my lord, as on today, my lord.
For the
Whatever-
offense
but
of, for the
whatever-
alleged offense of
My lord, commercial, my lord,
Ganja.
guns.
is the ground.
My lord, my ground is that, my lord, that nothing has been recovered from my possession, from our possession, my lord, and the two vehicles alleged to be involved in this case, my lord, that vehicles were not belonging to the petitioners, my lord. And
So where you picked up?
one thing, my lord, and my lord, learned prosecution, my lord side, has relied on only one document to, and they're trying to make nexus in the involvement in the alleged offense, my lord. Just one document, that is in kindly see
Where you? Complainant Mohendra.
At-
Ruling.
kindly have a look at page, my lord, page 15 or
As the
page
Just a
15, my
minute.
lord, FIR, my lord.
Page?
Page 15, my lord, FIR.
Is what I was trying to be.
May I read, my lord? Listen. With due respect and humble submission, I beg to state that yesterday at around 12 AM, I proceed for night patrolling. During night patrolling, at around 2:30 AM, a scooty bearing registration number so-and-so was suspected and followed. As the driver saw the police vehicle, he turned off the lights but continued moving. Due to the road condition and the weather and condition of the vehicle, the scooty disappeared in a moment. After approximately 400 and 500 meters near Gormo High School on Hardatta Virdatta Road, the scooty was found with 3 plastic bags suspected to
Where were
contain
you?
ganja on it. my
Who
lord.
are you?
My lord, I
Amongst
am not the owner of that scooty, my lord.
Okay.
Yes. And
And
therefore,
the
my lord,
Baleno vehicle?
no, we are not.
Why were you arrested?
My lord, only arrested, my lord, there's, in this case, my lord, they are shown arrested, my lord. Shown arrested.
You were already inside.
Yes, my lord.
In the dark case.
But my lord, in this case, my lord, nothing has been recovered from our possession.
Cannot be you are inside.
But my lord, only one document, my lord. There,
Where is the document?
that document, my lord, at page 20, my lord. Page 20, that in Caesar list, my lord. They've stated, my lord. They relied on that document, my lord, only on that document. That is, my lord, page 20, para 2, my lord. One duplicate car leasing agreement, self-declaration, my lord. One duplicate car leasing agreement, self-declaration form in between owner of Go Easy Tours and Travels, Sri Mukul Singh, Hezatavon so-and-so, and Sri Kumud Boro. That is the petition number 1, my lord. Son of Khogen Boro of village, Balahati, PS Goreshwar district, Tamulpur, Assam, for one Baleno vehicle by registration number so-and-so. Pick-up date, very interesting, my lord. That is pick-up date, 2/5/2024. And the, my lord, drop date is, my lord, 4/5/2024. My contention is that, my lord, the alleged incident, my lord, took place on, my lord.
You are Kumud Boro.
Yes, my lord, Kumud Boro. And
you took the vehicle, you did not return it.
My lord,
Simple.
You took the vehicle, you did not return it.
My lord, yes, that is, my lord, drop date, my lord, 4/5/2024. On the
My lord,
drop date, my lord, that is drop date.
My lord,
And
here,
for 2 days, my lord, that vehicle was hired, my lord.
my lord, I have
And
gone
that
through the
vehicle, my lord, at that point of time, when the police has, my lord, seized the
Petitioner was not there inside the vehicle.
my lord.
He was there or he was not there?
By the way,
my lord, and LS incident, my lord, took place on, my lord.
How many witnesses gone?
my lord,
My lord.
my lord, I have gone through the record, my lord. Total, I have gone through the record, my lord. Total 13 numbers of witnesses in charge sheet, my lord. And out of, my lord, 13, 9 numbers already examined, my lord. And the scan copy which we have received, my lord, it is earlier, my lord, 2 earlier, my lord. It is month of August, my lord. And what happened in the trial court, my lord, it is not in the record, my lord. That's why I prefer sometime, my lord, to update the status report. If whether any witness examined, my lord, and fix it in the next week, my lord.
My lord, already I have annexed the 7 numbers.
No,
of
no, no, no.
witnesses, my lord.
Thereafter, some witnesses examined.
Yes. I have 7 numbers of witnesses, my lord. I have annexed, my lord. But nothing is there, my lord. No one has whispered, my lord, against us, my lord.
9 witnesses examined up to 14/7, my lord. 9 witnesses examined up to 14/7, my lord. And remaining what is
My lord,
up to
not
the
Did
status.
you get the updated
My lord.
status?
But then for that maybe can. Otherwise, my lord, nothing is. Already I have
When
annexed
will you
the
get it?
7
My lord,
numbers of
it will come
witnesses.
for
my lord.
registry, my lord, in the next week, my lord.
So we kindly have a.
One after 2 weeks, my lord.
Weeks is my lord.
Last
Already
3
this. I have already annexed the 7 numbers of witnesses. My
When were
statement.
you arrested?
My lord, I was arrested 3/6/2000. 3/6/2024. 6/8/2024.
My lord, the 2 arrest, my lord. Earlier, another case, so
One
arrest, my
arrested.
lord.
What about the other case?
My lord, it is also commercial.
Pending, my lord.
No,
Other
no,
cases-
there have you obtained bail? No. The other
That case, my lord, granted bail, my lord.
granted bail.
Yes, my lord. In Tamulpur PS, that is the document, my lord.
Very
Bail order
great.
is there, my lord.
Let us see.
In this case, nothing is there, my lord. In the 7 numbers of witnesses, my lord, examined, my lord, I have annexed. Even not a single witness has whispered against us, my lord.
Oh, that is because of the statutory period.
My lord, my lord. Lordship already, my lord, come to the conclusion that, my lord,
I say already.
whatever Lordship is fine, my lord,
80
in
days.
the, from the FIR, my lord, they played over and taken in the hired on that day, my lord. And when police came, they played over.
I have annexed, my lord.
Document fix after 2 weeks, my lord. I will, it will come to the
The,
register.
by the last order dated 24/11/2025, the learned APP was permitted to go to the statement of the witnesses recorded during the trial. The learned APP has submitted that although the records reflect that 9 witnesses were examined up to 14/7/2025.
My lord.
Hmm?
My lord.
Comma. The case may have proceeded further in the meanwhile.
My lord. Scan copy up to 26/8.
The scan copy available is up to 26/8/2025.
My
Stop. Registry to requisition the scanned copy of the proceedings of the trial conducted after 26/8/2025.
My lord.
And place it along with the records. Just again on after 7 days. You give it after 7 days.
After 2 weeks, my lord.
Huh?
2nd week of December, my lord.
The 9th.
9th.
The 9th of December 2025. Stop.
Oblige.
Huh?
Oblige.
Yes.
May I please, Lordship? Lordship, the present petitioner is being booked under section 6 of POCSO Act, Lordship. Lordship will find the FIR at page 10, Lordship. Lordship, this case is a case pertains to a love affair between the victim and the present petitioner, actually. And as of today, Lordship, 133 days behind.
Yes, sir.
Yeah, so the victim is around 16 years of age. Her date of birth, Lordship, according to the birth certificate, is 2009. And I have flag marked the scan copy, Lordship. Her 183 statement has also been recorded. And altogether, Lordship, there are 7 PWs. Till date, Lordship, she has not been examined as of now, Lordship. The records, Lordship, reveals last date was 26/9/25. Cognizance was taken. Thereafter, Lordship, it was fixed on 29/11/25. So it is fixed for appearance only, Lordship. He has not yet been examined, Lordship. Otherwise, Lordship, the medical report also I have flag mark, Lordship will find.
That the girl is a minor and that he, for having stayed with her and caused her to become pregnant, is something which will entail the penal provisions.
Yes.
We do not find that the girl herself was making a complaint or the parents or anybody. There was any complaint.
Yes, Lordship.
From any.
Yes. That is there, Lordship.
Now,
Otherwise, Lordship, the POXO is extracted, Lordship, as well as 65 is extracted. In her 183 also, Lordship, she has stated, she has not implicated directly, Lordship, but what she means to say, Lordship, it attracts the penal provision, Lordship.
It attracts.
It
Now,
attracts.
that is why we try to differentiate it.
Yes.
Bail to be rejected.
I understand your Lordship's predicament,
It's
but
the things that we would like to see is whether he would influence the witness.
yes,
No question, they are not in fight.
no,
So he would not be trying to influence her in any
Yes.
other way. There is no fear
yes,
as such. Tutoring is otherwise of fear, but
Yes,
if we
yes.
keep the child and him away
yes,
as a condition,
yes. Just
that
one
is
thing.
still required to be behind bars during the trial.
For that, Lordship, I'm just pointing out one thing, Lordship, the medical, if Lordship kindly takes up the medical. I have put a flag mark, Lordship will find.
This is more to, this law is more to punish than to.
The findings of the medical report, if Lordship sees, are suggestive of recent abortion. So, Lordship, in the meantime, what has happened, Lordship, the abortion has been done.
Where?
In the medical report, Lordship will find the findings.
Garments.
There are one or two flags probably, Lordship.
Flags?
Yes. Second flag, Lordship will kindly see the medical.
Second flag is a statement under
Then
183.
First flag, Lordship will find the
Detected, not detected, no abnormality, average, cooperative, no abnormality, not advised.
findings are suggestive of recent abortion. That part is there, Lordship.
No evidence of so-and-so. Also, no pelvic free fluid noted. Impression.
Yes.
Features suggestive of type 1 RPOC.
No,
Is
Lordship.
that one you're saying?
No, that is there. Lordship. Findings are suggestive of recent abortion. In the statement also, yes. In the statement also, she has stated the same fact that she was made to abort the child, Lordship. So that aspect is,
Suffering from some pain.
he is a minor, her consent doesn't matter. So in any case, Lordship,
কারণে
another aspect is, Lordship, the petitioner is also a young boy, Lordship.
Very young.
Very young.
16 years.
And others, Lordship, they are appearing for the informant and the
Informant
respondent.
is, what do you say?
Support person. I was informed by midwife. So,
You have done your duty well. That part we are.
Yes, Your Lordship. Your Lordship, just one point I want to bring, that when abortion was done, they had changed the victim's name and many discrepancies there. So I think there is a criminal intent. Your Lordship, they have changed their name, they have increased her age. So all these things may be considered, Your Lordship.
Criminal or fear?
Your Lordship, for reasons best known, I don't know.
Right.
It has come to my knowledge.
She is appearing for the.
The reason for her abortion, she has stated something else.
Pain. She
Lordship, it was done in a private.
Is pain and bleeding, huh?
bleeding and pain, suffering from pain and bleeding for that abortion took.
Another counsel is appearing for the mother informant.
Yes, what do you say?
Victim.
What do you say?
The rest I leave it to your Lordship. Leave it to your Lordship. Lordship,
How many witnesses done?
not done, Lordship. Not yet started. Lordship. Altogether, there are 7 PWs. Not yet started, Lordship.
Lordship, in POXO Act, it's also very important to see the object and reasons of the POXO Act. The POXO Act does not intend to criminalize the consensual romantic relationship, Lordship. I mean, this case is a completely a case of a love affair between both of them, Lordship.
If we take that view,
Even then I disagree,
most of
Lordship,
the people would go home so happy.
because the definition of child is very specific in the POCSO Act.
Lordship, if I also stress one more point, that is regarding the ingredient of assault as laid down in section 6 of.
Assault is not there. That is what I was mainly
Yes,
thinking.
Lordship. So in
Assault
consensual
part.
acts, the fulfillment of that ingredient. is
Anything done per the law, assault, but she has not alleged that I was forced, I was coerced, I was nothing.
Her consent doesn't matter, Lordship. She is.
Doesn't matter, no doubt.
I pray at least the victim and the informant, they are not examined.
There is no any chance of hampering or tempering or threatening the witness or the victim, Lordship.
The victim, you say the guardian of the victim is saying no objection. I don't fear. So,
Maybe it may be considered.
Huh?
Kindly, the bail pray maybe this stage. Already 133 days behind.
take down heard Ms. Swinsola, counsel paying for the petition. Also heard Mr. Sharma, learned counsel paying learned APP. Miss
For the informant.
informant is paying for the mother of the victim. Then bail application. Paying for bail of the accused who is who is in detention in connection with Satgaon PS case number so and so, registered under so and so section of the POCSO Act 2012. The petitioner was, the accused was arrested on
August 18/7.
17/7/2025 on the basis of an FIR lodged by the informant, who was who is the
Rita Burman, support person.
by one Rita Burman, support person within bracket access to justice of Assam Center for Rural Development. Full stop. In the FIR, the informant had stated that during a field visit near the Amsing PHC, they received information of the ANM of the Amsing PHC regarding a suspected case of child marriage. As per her information, a 16-year-old girl named Archita, 16-year-old girl was currently residing with the accused, who was stated to be around 18 years and 17 months.
18 years, 7 months, Lord.
18 years and 7 months. Full stop. The victim was reportedly pregnant. Full stop. The petitioner was arrested on 17/7/2025 and forwarded on 18/7/2025 and has been in custody since then. Full stop. The scanned copy of the case records of session special case number 193.2025 in connection 25 has been received and perused by this court. Full stop. The learned APP submits that the trial is now at the stage of appearance of the
Appearance and SR.
appearance and service report, public production. Full stop. from the record, it appears that the matter has been thus fixed on and from 26/9/2025, and the evidence of the victim.
Not yet.
Now, the prosecution evidence is yet to be, yet to start.
Yet to start.
The counsel for the petitioner has submitted that the petitioner is a young boy of 18 years, approximately 18 years, and there is no suggestion of any coercion, force, or assault, even in the statement of the victim as recorded under section 183 of the BNSS, full stop. The learned APP and the counsel appearing for the informant have stressed that there the abortion undergone by the victim would itself show that there was a criminal intent on part of the accused, full stop. Accordingly, they have prayed that the bail application be rejected at this stage, full stop. We have gone through the records. So we have gone through the scanned copy of the records and the statements made in the bail petition, full stop. In view the young age of the accused and that there are no allegations of force, coercion, etc. The only full stop, no coercion, etc. We deem it fit to grant bail to the petitioner. And rest of the condition did you apuni present bail bond duties, satisfaction of the trial. Akibilak did not to contact the victim. Not to contact the victim, coerce. Yes, we are granting the bill. Young boy now, if he stays behind, will get into more trouble with those people.
Obliged. I'm deeply obliged, Lordship.
Yes.
Maybe your lordship. Lordship, it's a case of POCSO under section 4 of POCSO Act. And the case is registered under Jamuguri PS case 104/2024. And I'm behind the bar since 8/8/2024, 8 of 2024. Your FIR is on page number 8. Bhiksu said that today, dated 8/8/2024 morning at around 8 a.m., my father, Mohammad Nur Jamal Ali, tried to lure my 7-year-old daughter, Miss Sahima Nasrin, by promising her give bananas and handed over a 20 rupees note in her hand and pulled her inside and tried to put inside his finger on her private part. And as a result, my daughter, out of pain, ran outside my father's room and then fell down on the veranda. When I asked my daughter, she cried and told me
yes.
Lordship, I have flag marked the scan copy. It is, and Lordship will kindly peruse only the medical report. That will be enough. I have flag marked, Lordship. Findings, Lordship.
This is a bail petition.
Lordship, just want to give a submission, Your Lordship. The actual fact is that on the day of occurrence, that
Can you make a
victim was-
request, sir?
Sir?
Dated 26/11/2025, full stop. List again on 10th of December 2025 along with service report.
Obliged, Lordship.
Please, Your Lordship. Your Lordship, this is a delay petition. Morning I have mentioned it. I was trying to mention, then Your Lordship told me to wait and reach them.
Yes,
Service is complete, Lordship, here.
service is complete. Will appointed and
Yes.
Insular Council appears for the applicant. APP submits that service on the respondent number 2 is complete. However, none appears today on her behalf. This court deems it appropriate to appoint an amicus curiae in the interests of minor victim. Stuff accordingly.
Dixit Gogoi.
Gogoi. Requested to participate in the proceedings as an amicus curiae to report the rest of the respondent number 2. We'll stop. Place this again on
Your Lordship.
10th of December 2025.
December.
Stop. Registry to provide a copy of the.
He will provide, Lordship.
I will provide a copy of the petition to Gogoi. London amicus curiae appointed.
Well.
P7.
Thank you, Sir Lordship.
Mm.
Sir, as far office note, Your Lordship, the service upon the respondent number 2 is awaited.
Is
Awaited.
awaited. Administrator Surinsular Council appearing for the petitioner, comma. Mr. Bisham Learned APP appears in the matter. Stop. As per the office note, the service report on respondent number 2 is awaited. Again, on the 11th of December 2025 with service report. Yes.
We have challenged by a judgment of the 12/10/2015 passed by London Additional Session Judge in criminal appeal regarding that affirming the order of the General Judicial Magistrate whereby the petition has been directed to pay ₹7,000 per month to the opposite party under DP Act, my lord. That is the judgment. Now, the complaint that is at page 15 filed by
Page?
at page 15 the complaint
1-5.
1/5.
What are the where is that order which you are selling?
That error which I have assailed is at page 38.
Page 38. Can you tell us why it is wrong?
Wrong means the courts below board. Both they have overlooked the evidences, my lord, as well as did not consider the contention of the petitioner, my lord, because there are some vital facts, my lord, which are overlooked, my lord. First, my lord, that she left her matrimonial home, that marriage was held in 9/4/2007. There is, and after 6 years she's left. Only on the ground, the petitioner is a school teacher. He lives in a village area. And she wants to live in near her parents' house, which is an urban area in Silchar, my lord. So that is the mainly reason, one of the reasons that dispute arose, man, between them. Then she left on her own matrimonial home, my lord. And then she also, in her evidence also, it has been revealed that she wants a high standard of living because her father is also a very rich family, my lord, and he is a small school teacher, my lord. That is also another reason also. And there was also, the Bishar was also held, my lord, in the Gaon Panchayat level, my lord. And during that, Bichar, that she did not come for reconciliation. It also come in her evidence also, my lord. Evidences, my lord, that she did not want to reconcile also. And then the finding no other way, have to give talak to her also, my lord. Mainly. And during the talak process also, there was reconciliation process, but that she did not come up, turn up, my lord. These are the reasons, my lord, which are overlooked by both the courts below, my lord. And with the bag complaint, my lord, only one incident, that was the father-in-law took her one day in absence of the petitioner and dropped her in a parent's house, as the allegation appears, my lord, and not the petitioner. And on that basis, my lord, the complaint has been filed, my lord. He also lost the 498A case also, that is not charged yet, my lord. And she refused to come back in spite of several attempts made by.
Lordship, may we take, Lordship?
She stayed only for a brief period in a matrimonial house, my lord. And her own statements also reveal that she did not want to stay, as well as she did not, her own statements in evidence, my lord, she reveals that she did not want to stay in the matrimonial home because, as well as she also did not deny the contentions of the petitioner in a written statement. She herself said that she belongs to a rich family and so has landed property also. So while the petitioner has to maintain his parents as well as his unemployed brother.
So, this was given as maintenance to her.
As maintenance, so 7,000.
Yes, which may be an order under. So 7,000 out of 30,000.
Not, it is a matter of not a question of 7,000. My own thing is that she did not want to live with him only because he stayed in village area and he belongs to lower strata of the and while she belongs to a rich family, man, that is the reason. And also there must be a prima facie grounds, my lord. In the Supreme Court, Honorable Supreme Court also in one of his decision, my lord, has stressed that there must be a prima facie ground, my lord. The court was satisfied that there are instances of violence before issuing a notice of complaint. There is no violence, my lord. Only vague statement has been made, not specific. If a lordship goes to the complaint, that's why a lordship wanted to bring to the. I want to.
Appellant DW1 has admitted in his cross-examination that he did not maintain the PW number 1 since 17/1/2010.
Yes.
So somewhere you had admitted that you did not maintain her after 17/1/2010. Can we have a look at that part?
But she left her at the time. She
When 17/1/2010 she left.
She left.
Either you kept her there or she left on
She
her
left
own.
she stayed in the matrimony.
Either of the two conditions.
After 3 years of marriage.
Either of the two conditions till the time when the marriage is annulled.
Yes.
Some liability of a maintenance will always be there.
Liability subject to the thing that it's, that if wife refuses to stay with me, then I cannot.
Where did
help
you
that
prove
person.
that?
My lord.
That proof? How do
In
you
a
come to that
depositions, I have
conclusion?
already stated my grounds I have taken, my lord.
No, wait,
As well as
how do you
where-
come to that conclusion? Show us something
That
from the
evidence, you have
documents.
to go to the evidence in that case.
Where is it?
Statements are also revealed that.
That she left on her own. Huh?
I'm not saying like that, but only thing is it reveals like that, that she does not want to stay.
Let us see. Let us see complaining.
That statement, PW1.
On which page?
Actually, I have not annexed that, it in vernacular, I must say. Actually, these statements are, or depositions are in vernacular.
So, tell, go to.
I don't-
This is of 2015.
15, yes.
Are you getting any maintenance? Are you paying anything? No.
I've been told, but there since there's no stay order,
Uh,
so most probably he is paying, madam. I have been informed, madam. Earlier, now I don't know. Madam. He will
Sometimes
get- he can
4,000,
stay.
my lord,
He can stay,
sometimes 4,000, sometimes he is getting more than 1 lakh salary now. My lord.
LP school, I don't know whether he gets 1 lakh now, teacher, LP school teacher, madam.
where is your statement that you cannot maintain yourself? You want a high life?
So I have filed, my lord, I have in opposition here.
Huh?
I have filed here in opposition, my lord.
Yes, yes. Whose statement were you referring to?
At PW1,
PW?
Sakila Begum Laskar. You will
Huh?
actually got it. PW1, Sakila Begum.
Hmm.
Yes. That
2007 ইংরেজি
two,
আমার দুটা হয়
can I?
এরপর 1.5 বছর ভালোভাবে
He was repeatedly taken back.
আসি তারা বারবার আমাকে নিয়ে যান বলে কোনো ঝগড়া করে খোঁজ দিয়ে না নিশ্চয় এরও ওরা বেশি হয় মারধর করে Now the trial court has refused to believe that anything happened prior on 2013. Trial court refused to believe that part of your story. How does it come to a conclusion that in 2010 he had committed anything? He says that the trial court says that you admitted it. The husband admitted it. Where? Hmm? What is the husband's name?
This, my lord, Jasimuddin Laskar.
Is
Jasimuddin Laskar.
DW1. Is DW1?
DW1.
Yes. What does the DW1 say? Yes, show us that from where this inference has been drawn that he has let you go or he has dropped you at your father's house. From where can we find that?
The page 15 of the petition, my lord, and actual one, there is complaint she filed.
Complaint she'll make all allegations and in complaint the 2013 part has been disbelieved by the court. Have you seen? Have you gone through the records totally or you are yet to go through it? The petition itself.
Petition I have seen, my lord.
Petition you have seen. Page 47. Last few lines. Do you have page 47?
Yes.
Last lines, however, last 3 lines. What does it say?
Consider these facts and in
Hmm?
vehicle use.
I am unable to believe the occurrence dated 26/13. I am unable to believe occurrence dated 36/13. All these are disbelieved.
Yes, madam.
It is found, then you come down below, it says,
The middle portion also says, my lord, in the middle portion, nevertheless, domestic violence is a continuing offense.
so prior to that, there must have been some incident, some proof of domestic violence. Where is that? EW1 in his cross-examination. Even the kind of broad matter, it a Yes, in his cross-examination, where have you stated that I have not maintained her after that? Yes, you admitted that from 17/1/2010, you have not given any maintenance in the cross.
After, after that, as she left the house, definitely there was, of course, maintenance was not given. But one thing also, in her cross also, step she said, আমি অত্র মোকদ্দমা আমি আমার বাবা একজন সন্ন্যান্য ধন্য ধনী লোক, financially sound.
Where?
In the statement,
in her statement,
deposition, madam. Cross, madam. Cross word. Well, she was got it. আমি অত্র মোকদ্দমা আর্জিতে আমার বাবা একজন স্বনামধন্য ধনী লোক, ফাইন্যান্সিয়ালি সাউন্ড করে, আমার ভাই হাই আর্নিং এবং ওয়েল রেপুটেড।
মারা যান।
আমার বাবা আমার বিবাহের আগে মারা যান। আমার বাবা
বিবাহের আগে
he has landed property also.
Yes.
That part is also there. That is stated, my lord. জমির উপর ভাড়া কর ও সর আর কি না জানি না।
Yes.
That reconciliation period also, she has also, part also, she has.
They did not, even they could have filed the restitution of conjugal right if they wanted to, that didn't opt for, my lord. Also, now above all, my lord, about the maintenance portion is all, my lord. He's entitled otherwise.
The only ground on which maintenance can be denied is if you live on your own. Is it not?
My lord, they have made such situation.
Where is it? Show us. Where is it? Their allegation is that you belong to a very high level family and therefore you don't want to stay
Father
with
was,
them
my
and
lord,
keep
but-
going away.
No, no, my father died, my lord, prior to that. That also been stated in the. Father was reputed. Now nowhere, none remains here, my lord. Only myself.
আমাকে লাঠি ঘুষি মারিয়া থেকে সেই 498 এফআইআর এ আমি আমার স্বামী ইমান উত্তর ইমান আলী এবং মেয়ের সঙ্গে You also lost in 498A.
Oh, that is also there.
What happened to it?
But also I am.
That part, my lord.
We are not saying that you would be entitled or not entitled, but what we find from here is that many crucial aspects have not been taken into account while granting the maintenance. After considering that you had filed a 498A, that you had left the house on your own because of the torture and everything, this and that, you are entitled to a maintenance. We have nothing to interfere. He has applied his mind to every aspect of the matter. Here, whatever is the evidence, somehow we are finding that he has not considered all the aspects.
Overall
If
evidence.
that has not been done, then he would have to reconsider it based on the evidence available on record.
My lord, but that is right, my lord. Your lordship is correct. But regarding the entitlement of maintenance, my lord, in that part,
That entitlement has to be decided on what? The evidence available.
Yes, my lord.
When one of the reasons for disentitling a person is that when she deserts him. When a lady deserts the husband, no maintenance. Is it not?
Yes, my lord, that.
125 CRPC is on desertion, you will not be entitled to maintenance. The very ground he takes is desertion. You went away on your own. What this court is feeling is that that ground that you left on your own has not found any mention in the impugned orders of the trial courts. Once that was addressed, that we do not find that it is a case of desertion. It is a case where person has abandoned. Immediately, yes, whatever rest of the conclusions that he comes to, this is the amount I think is good.